Any mention?
Yes.
Your Lordship, I beg to mention item number 29, Your Lordship.
Number?
29.
Maxim.
Yes, Your Lordship. Already informed the other side, Your Lordship.
Why?
The conducting counsel needs some more time to do the hearing, Your Lordship, to prepare for
What's
the
the matter
hearing.
about?
Our Lordship, this matter is being handled by Miss S.
I'm asking what's the matter about.
Lordship, I don't have the brief.
Handling the matter.
Lordship, I don't have the brief with me, Lordship.
In 2 weeks, yes.
Much right, Lordship.
Lordship, I beg to mention item number 25, Lordship.
What's the matter about?
Lordship, this is a matter where this man was electrocuted, Lordship, and ex gratia payment was.
Oh, he lost both his arms and legs.
Yes, Your Lordship.
Lordship.
He's got the money, at least first.
Lordship. He's been given the ex gratia payment.
What are the instructions?
Your Lordship, it's fixed for hearings.
It's for hearing, we know.
Yes, Your Lordship.
Okay, 2 weeks, yes.
Much right, Lordship.
Much obliged.
Your Lordship, I beg to mention item number 16.
Number?
16, Your Lordship.
And for the petitioner, Lordship.
Why?
Your Lordship, the conducting counsel case Karsi is unwell.
How long?
Yes, Your Lordship.
21 matter, 1 week, okay.
Lordship.
After 1 week.
Highly obliged, Lordship.
Yes.
Please, Lordship. Lordship, I want beg to mention item number 27, Lordship. Let it come after 3 weeks, Lordship.
What is the matter about the same?
Financial upgradation, Lordship. She is seeking financial upgradation and completing 30 years of service.
2 weeks, yes, okay.
Highly obliged.
Yes.
Lordship, I'd like to make a mention for item 17, Lordship.
Do you have objection?
No, Your Lordship. As per the instruction of the conducting counsel, he said a last chance may be given.
Yes, but escrow account?
Yes, Your Lordship, escrow account.
So,
22 matter, 1 week is.
no, Your Lordship, because senior, he said Bihu holiday will start, so kindly fix on 30th of April.
After 2 weeks, Lordship.
Now it's after 4 weeks, okay.
Really obliged.
Yes.
Please, Lordship. Lordship, I beg to mention item 28.
Number?
28, Your Lordship. Your Lordship, in this matter, there is a scope of settlement, Your Lordship.
There is?
Scope of settlement.
Is that correct?
I have no instructions, Your Lordship. Your Lordship, it's a dispute between two wives, Your Lordship, fighting for the pension of the husband.
You're paying for other wife. Who's paying for other wife then? Who's the paying? The private respondent. Number 28? They say they don't have any idea. Okay, after 2 weeks.
Your Lordship, I beg to mention item number 22, Your Lordship.
22?
Yes, Your Lordship.
Who's for the other side?
Other state minutes.
Why? The service matter.
Yes, Your Lordship. Lordship, I prefer 2 weeks' time.
1 week. The service matter, what's there? Yes.
Your Lordship, another matter, Your Lordship, similar pref item 23.
As well adjourn the whole list then.
I'm for respondent number
yes.
1.
Yes.
For state, no objections, madam.
Yes. Yes.
Please, Your Lordship, I beg to mention item number 21.
Secondar Ali.
Yes, Lordship.
You're appearing for whom?
Respondent number 3, Your Lordship.
I'm for a petitioner.
Your objection?
No, Your Lordship.
No objection. 1 week, okay.
All right.
Obliged, Your Lordship.
Anything else? A few matters are left in the list.
Supplementary list, item number 1.
This is a transfer matter. It appears that both the district judge and the additional district judge also cannot take up this case.
Why?
Both of them have passed orders previously in the same connected matters.
What to do then?
It will have to be transferred to either another district. Either
So what do you prefer?
Nongpo or Joy,
Then who's the other side? Or state?
This state.
None appearing.
I can't appear in this matter. The statement is because I was for the private respondent.
Who's
In the main civil suit.
In the main civil suit.
This is against the Archdiocese. There was a civil suit pending.
Okay. Who's appearing for the Archdiocese?
I don't know if they have made a party in this matter.
No, they've not.
No, just a reference.
Yes, just a reference.
You take notice then. You have any objection?
Well, for the state, I can't appear. There will be a conflict.
You'll have any objection to transfer?
My lord, no objection since Sir has already pointed out that it can't be taken up, so no objection, my lord.
Yes. This ended in final report also.
Yes, and then we.
Then you filed. What have you filed?
We filed a revision. We filed a revision, my lord, before this court, and that order is at.
I don't have anything here.
Yes, that's
only
the problem.
A bare file.
The Lordship will have the revision petition, page 32, my lord.
Yes.
Heard so-and-so for the petitioner who has pointed out that in the course of these proceedings, an order dated 29/8/2023 was passed by the Honorable Supreme Court in the case of so-and-so, reported in so-and-so. By the said order, the learned senior counsel has left this court with the observation made at paragraph 11, which reads as follows. In view of the above, there remains no shadow of doubt that on receipt of the police report under section 173, the magistrate can exercise three options. Firstly, he may decide that there is no sufficient ground for proceeding further and drop action. Secondly, he may take cognizance of the offence under section 1901B on the basis of the police report and issue process. And thirdly, he may take cognizance of the offence under section 191A on the basis of the original complaint and proceed to examine upon oath the complainant and his witnesses under section 200. It may be noted that even in a case where the final report of the police under section 173 is accepted and the accused persons are discharged, the magistrate has the power to take cognizance of an offence on a complaint or a protest petition on the same or similar allegations even after the acceptance of the final report.
Okay.
So on that basis, we withdrew the petition and filed. Now both the courts have said that, I mean the district judge and the...
Yes, take down. This matter has been placed for the bench for necessary orders. The reasons for the same, it appears, is that criminal revision case number 2 capital H 2024 under section 397 CRPC Sri Paul Yong versus State of Meghalaya will not be possible to be taken up by the courts in Shillong. That is the district and sessions judge as also the additional district judge, as they have recused themselves from the said matter. Stop. Next paragraph. Mr. T.T. Ringdos raised that the matter may be transferred to Court of Competent Jurisdiction either in West Khasi Hills, Jawai, West Jant Hills, or
Riboi district,
or Nongpor district. So take your pick.
Will it be Nongpor, Mala?
Yes, taking into account the distance, the above mentioned civil revision case, so and so, shall stand transferred to the Court of District Sessions Judge, Riboi District, Nongpor, for disposal. Stop. Records all before this court? Don't need the records. Huh? Only this will do.
Only this will do, Mala.
For a time being, the records as present, as available, be transmitted immediately to the Court of Nongpor. Parties put to notice to appear on
2 weeks, my lord. 24th.
On 1st, where's May? On 1st of May, 2024.
Much obliged.
Item number 2.
Transfer petition stands disposed of.
May I please, Your Lordship?
Yes.
That the brief fact of the case is that the petitioner deceased son.
The petitioner's
Deceased son.
deceased son.
Son. Late
The
Vijay.
son's dead. Okay, yes, the one
Vijay
happened.
Pradhan was working at 23rd Battalion of Border Security Force at Rajasthan at the capacity of constable, who died on 31st August 2021 while on his active service. That the petitioner, deceased son, and the respondent number 5 got married on the year 2010, and out of the said wedlock, a son was born to them on 17 March 2012, who was later named as Ayan Pradhan. That after the death of the petitioner deceased son,
Then 21. The deceased, the employee died in 2021.
31st August
And
2021.
he got married. He got married to this.
He got
one of
married with the respondent number 5 in the year 2010.
Okay, 2010. Then what happened?
Then, after the death of the petitioner deceased son, the petitioner claimed the death and the service benefits of his deceased son before the office of the respondent number 3, as well as respondent number 5 also applied for the same.
Someone applied for the same also.
Same.
Okay.
Thereafter,
So she'll have first claim. The respondent number 5 will have first claim on the retirement benefit or whatever family pension.
yes, I'm
What
coming.
happened?
I'm coming to
Yes.
this, Your Lordship. That thereafter the respondent office, respondent number 3 office, has addressed a letter to both the petitioner and the respondent number 5 for production of succession certificate to settle the pensionary and family benefits of the petitioner deceased son. That I would like to mention here that the respondent number 5 has applied a succession certificate at Kharjian, Darjeeling district for grant of the succession certificate, and asked the petitioner for to provide his no objection certificate. That Your Lordship, the petitioner deceased son's death service benefits and family pensions were not debts and securities which can be settled by grant of succession certificate. Also, I'd like to mention before Your Lordship that the respondent number 5 deserted the petitioner and got married to someone else, and she never returned to the petition.
There was no divorce.
No divorce. No divorce obtained.
Yes.
And she never bring the only son of the petitioner deceased, grandson of the petitioner deceased son, to perform the last rites and rituals. As per Hindu belief, the last rites shall be performed by the surviving son of the deceased person. Also, the petitioner is in. Also, the respondent number 5 working as West Bengal Police Department. Hence, the claim of the respondent number 5 is not maintainable at all, Your Lordship, in this instant matter. Also, I would like to humbly submit before Your Lordship that the petitioner is an aged and retired person, and the pension he is receiving is not sufficient for his day-to-day expenditure as well as.
But he has a son. But he has a son from this respondent number 5, correct?
Yes, Your Lordship.
Yes, Dr. Mosika, what kind of case is this?
But
she remarried.
They have stated that she is remarried, my lord, in Darjeeling somewhere, and taken the son
During
out.
the substances of her first marriage, Your Lordship, she already got
And she's
married.
in service with the police, he said.
Yes.
West Bengal police.
West Bengal Police.
Because widow will be entitled only till the date of remarriage, my lord. The widow will be entitled to pension till remarriage, my lord. If she is remarried,
That is what, no, but there is no
but
divorce.
the
So
grandson-
remarried, she
son will
remarried
get.
during the subsistence of the first marriage, number 1. Even then, if she married again, even for her own services is jeopardized. But number two is that her son is there.
Son is there.
Yes.
So when son is there, whether father will be entitled to any pension. But from the department, we have written to them, do you bring a succession?
Succession certificate has not been, he has not got any succession certificate.
No,
correct?
no, Your Lordship.
Then let us issue notice, let her come. Yes, sir. Third MS, sir. Name?
Arpol.
Third MS Arpol, Council of Petition issue notice. Dr. Nozika,
1 to 4.
Present on behalf of 1 to 4. No further notice called for. Steps to be taken for service notice on this part number 5 within 3 days by said AD. Just after 3 weeks. Yes.
Much obliged, Your Lordship.
Item number 3.
May I please, Your Lordship? Here, my Lord, we are aggrieved by the action of the respondent in bifurcating one village into 13 village monitoring committees.
One village into how many?
13 parts. 11 parts, I'm sorry, 11 parts. If Lordship will recollect, my Lord, Lordship is pleased to come to page 57. Page 57, Annexure 5, Lordship.
Yeah.
Lordship, this is Your Lordship's judgment of 23rd of June 2022 in connection with Molakandi VEC, Lordship. If Lordship will...
Oh, the Molakandi VEC. Bifurcation to many VECs.
Lordship, yes. If Lordship is pleased to come to page 59 and paragraph 5, if I may read, Lordship, it appears from the material on record and from the submissions advanced by the parties that indeed there is some dislocation which has resulted in the mismanagement of the constitution and running of the Molakandi VEC. It is a settled proposition that a VEC cannot be bifurcated, except for compelling reasons. The impune orders have been passed whereby functionaries of the VEC have been changed in the course of the day, and further other functionaries have been appointed by subsequent orders for a portion of the village which appears to be without any basis. In view of the matter, the orders dated so and so shall be disregarded, and the impune order dated so and so shall stand quashed and set aside. Lordship will see the next paragraph also. Accordingly, respondent number 3 is, under the supervision of respondent number 2, is directed to examine the entire matter afresh and to conduct elections to elect new VEC and its functionaries, and to look into the matter with regard to the bifurcation of VEC, which seems to be unjustified. Entire process shall be completed within a period of 4 weeks, Lordship. Thereafter, my Lord, Lordship will see at page 61, this was the notice issued in pursuance to this order, my Lord. Election will be held for the VEC functionaries of Molak and the VEC. So they have made it into one VEC, Lordship. Election was supposed to be called for one VEC. Thereafter, my Lord, Lordship will kindly come to page 73. This is the order, my Lord, by which the 3 functionaries of the VEC have been, page 73, Lordship.
Yes.
In compliance with the judgment order passed by the Honorable High Court of Meghalaya via order number so-and-so, dated so-and-so, in connection with so-and-so, election was held.
So elections were held, so what's your grievance now?
The Lordship will, so 3 people were appointed for one
Right,
VEC.
okay, now that means orders of the court carried out there, the VEC,
Yes.
single VEC was there,
Yes.
elections held, and
Then Lordship will kindly come what has happened at page 74.
70?
74, from the next page, Annexure 10 in series, all the way up to
What happened?
all the way up to 83, my Lord. Lordship will see, in pursuance of the meeting held on so-and-so at the premises of Molakandi School so-and-so under the chairmanship of so-and-so, meeting resolution adopted, grievance are heard as demanded by job card holders of Molakandi VAC to provide employment under MG and REGS in different hamlet. Undersigned is pleased to approve the newly selected village monitoring committee as Molakandi Part South. 3 members, my Lord. Lordship will see page 75. Molakandi Part.
Okay, fine, it's been approved.
Yes.
What happened now?
So now, my Lord, Lordship will see page 74, 75 is, my Lord, Molakandi Part Bauni Vita. Then Lordship will see page 76, Molakandi Part West.
No, it was a very big village, then what is the harm?
No, there are 1200 villages right from the very beginning. Initially, they made it into 13 part VECs. Thereafter, it was found that...
It's just a monitoring committee.
No, there is no provision to have monitoring committees, my Lord. How they can have a monitoring committee? The direction was to have a parent VEC and to have VECs within it. Now here,
no, direction is not that. Direction was that VEC cannot be bifurcated.
Yes.
And so you can't have separate 2-3 VECs for one village.
So instead
and
of-
so after they had a big election, they elected the VEC, and then now they're having monitoring committees for different parts of the village. So what's the
How
harm?
this was done is not known to anyone, my lord. Only the orders have come.
Who are you?
I am the job card holder, my lord, who was here before this court earlier also.
Okay, yes, sir, Mr. S. Anything to say?
Your Lordship, I'll take instructions, Your
Yes,
Lordship. Correspondent
issue notice,
124.
returnable in 3 weeks. MS Ailingwa is present on behalf of respondents 1.
124, Your Lordship.
24.
Notice may be issued to all the others.
5237.
You want to create problems, that means, in the
No,
village.
I want to solve the problem.
You want to create problems because you contested elections also.
No, what is... I
Did you
am not-
contest elections?
Yes, yes.
Unsuccessful?
Unsuccessful.
So you're going to backdoor now to disrupt everything?
No, I have not agreed with that VC election, my lord. I have agreed
You
with
agree?
the
No,
VMC.
I think why are you making all these people parties then?
Because
You
they
have
are all
orders
VMC.
signed by the block development officer.
They are all VMC parties, my lord. What has happened is instead of bifurcating the VEC now, they have bifurcated.
Okay, for
changed the
for
nomenclature.
at this stage, no notice to issue private respondents. Government advocate to come up with instructions on the next date. Yes.
Obliged, Lordship.
This one, so and so. Let them come with instructions. If they can justify it, then no need to issue notice.
Item number 4.
Yes.
Yeah, please, Lordship. Your Lord, we are with a limited prayer for disposal of my representation, Lordship.
What representation?
Lordship, this is petitioner, my lord, is a union established for the purpose of welfare of these coal truckers and goods carrier
What welfare?
trucks. Welfare of the goods and coal trucks. It's a union of these truckers association.
So what welfare are you looking after?
Lordship.
What kind of welfare are you doing for these truckers?
No, we're giving them services for...
What
a certain-
services? See, truck drivers, handymen, everything. So what service do you give them?
Lordship will kindly come to my constitution, my lord. At page 23.
23.
23, Article 4, my lord.
Article 4.
At page 20. This union is there right from the year 2005, Lordship. They have spelled out the aims and objectives, my lord.
Now, what's the guidance you give? What you just write here to maintain close understanding, to extend assistance to all possible registered members.
We have a group of truckers, so we give them medical
You have
assistance.
ambulances or something like that. You
Yes,
operate.
yes, medical assistance.
You keep
then-
ambulances.
We basically outsource, my lord. Then sometimes these vehicle breakdowns, this and that. So all those issues.
Show what activities you've done. You file affidavit in the last 1 year.
Lordship, we'll do that, my lord. Thereafter, what has happened? Earlier, my
Yes.
lord, in the year 2013, Lordship will see page 33. We had come to this honorable court, my lord.
Yes.
We had established an office at Dynadubi. And because
Yes.
of some objections from the respondents, we had to come to this honorable court. And Lordship will see at page 36, Lordship.
Yes.
Paragraph 5.
Yes.
After hearing the rival submissions advanced by the learned counsel for the parties, I hereby order as follows. Henceforth, petitioners association shall collect membership fees only from the registered...
Suppose a truck doesn't want to become a member. You.
No, then we have not...
What do? You intimidate them to become members.
No, nothing
and
of
pay
that.
membership fee.
Nothing of that sort, my lord. Nothing of that sort. 1, 2, 3, 4, 5 directions were given by the honorable court.
What happened after that?
And we have been complying and running the office at Dynadubi, my lord. Now with the increase in number of the trucks, my lord, we were contemplating to establish another office in the West Khasi Hills district for the purpose of collection of fees from our members only and nothing else, my lord. So in that light, my lord, we had written a representation to the Deputy Commissioner to accord us permission at page 39. my lord. Original
West
is
Khasi Hills. Where you want to
West
put it?
Khasi Hills, my lord. Anywhere in West Khasi.
110 meters.
And yes, because that was the direction of the court, that it cannot be within...
You have a valid list of members updated.
Yes, my lord. If required, I can place all that.
So you want to start an office there.
Yes. So my only grievance is that, my lord, if they don't want to give us the permission, they can give it to us in writing. We will see what remedy to avail, but they should dispose it, my lord. And we have...
You want West Khasi Hills.
West Khasi Hills, my lord.
But then the constitution of yours doesn't allow operation West Khasi Hills. Just now you should look at Article 3.
There's no...
See, 3 you have limited your own jurisdiction. You read it. The jurisdiction of the union shall cover East, West and South Karul district in Meghalaya. Then why are you asking for West Khasi Hills? So you withdraw your writ petition.
Maybe it has been amended. I'm not sure at this stage.
Withdraw it. I will
Let
dismiss
them alone. Just give a reply. If they want to, don't. If they
It's
don't
also
want-
a jurisdiction by your own constitution.
No, maybe it has been. I'm grateful that Lordship has.
You haven't noted that when you prepared writ petition?
I'm very because it was not instructed also.
In Article 2, location and address of
Yes.
No, the office is main office is in Dino to be till date, my lord. So we had sought for permission to set up in.
We won't issue a simple order for this full writ petition. We'll ask for your entire member list. What you've been doing the last 4 years, 5 years. How many people have been benefited.
We'll produce all that, my lord. We'll produce all that.
No, but then you withdraw the petition because it's.
No, perhaps maybe there is an amendment, my lord. Maybe there is an amendment.
We can't go on that. Yes,
Lordship may kindly have it.
I will dismiss it, Mr.
Lordship
Judge.
may have it tomorrow. I'll just take instruction on this whether the constitution has been.
You can't improve your case after you
I
filed
understand.
it.
This is something which has escaped our notice also, my lord. Lordship may have it tomorrow. We'll try to.
Yes, the matter next week, yes. At the prayer of the counsel with the petitioner.
Fortunately, skipped our attention also.
Item number 5.
Obliged, Lordship.
Yeah, what is it, Mr. Chandraya, sir?
My lord, this petition is filed by the chief of the Maharam State Chief. My lord, in 2016, the complaint was filed by the respondent number 6 against the chief. And I have filed my response for the executive committee. Matter was kept pending. In 2023, they came up with the application for reminder, and the matter was proceeded, and we have taken the specific plea.
2006, they filed a complaint, the matter was taken up.
2016, yes. And matter was proceeded, and I have taken a specific plea before the district council that under Section 5 of the Maharam Act 2006, it clearly provides that the executive committee has the power to remove or suspend the chief.
Yes.
Provided the opportunity is given. First proviso provided that however, the complaint against the chief should be brought before the Barhima first, and thereafter the executive committee can proceed. So we took this plea. However, the district council declined to accept that argument and proceed the matter. Therefore, I approached before this court, and my lord has directed on 1st March of this very year, directed this council to look into these objections.
Okay, to look into your objections.
Yes, to look into my first plea. Now, thereafter, I filed my written argument with the submission, and matter was proceeded. And district council has passed the impugned order, saying that the first proviso is only a directory, number 1.
It's only directory?
Directory. It is not mandatory. Okay. And number 2, they have taken the plea that I was appointed in 1991 under the Appointment of Successor Chief Act 19...
What Act? 59 Act?
Yeah, 59. So they say that they can take action against me under that also. Now, Section 11 of the Maharam Act is very clear that the...
All acts repeal?
Yes, my lord. The Act of 1959 stands, my lord, not applicable to the extent it is provided under the 2006 Act. May I show, my lord, the very provision? What you can see.
You've annexed it in your petition?
My lord, I have annexed the Act also. Lord, you can see page number 19.
19.
19, my lord.
Okay.
Section 5, Lord, at the bottom, Lord, you can see.
Section 5. If within 30 days. Or
My
term of office.
My lord, term of the office, my lord.
Yes.
The same of Maharam shall be appointed for life from the date of his appointment. However, in the event of any complaint against the CM, which prima facie disclosed that he has violated any of the terms and conditions of his appointment, Sana, or that he has lost the confidence of the majority of his electors, or he has been conducted himself in a manner derogatory to his office, or which may undermine the authority of the council, or he is found to be mentally unfit or incapable to carry out the administration of the HIMA due to his ill health, old age, or habitual drunkenness, the executive committee may, after inquiry, suspend or remove him from office, provided that any complaint against a CM shall first be brought to the knowledge and notice of the Darbar HIMA, provided further that the CM shall not be removed or suspended from office unless...
Okay, Mr. Char, you're saying that this proviso, it's mandatory that any complaint against this CM must be put for Darbar HIMA first. But Darbar HIMA does it have any power by itself to examine the complaint, or it remains like that, only knowledge?
That is the plea taken by the council also. Now, this council has taken a specific plea that even if a complaint is brought before the HIMA, HIMA has no power to inquire or conduct any actions. Because of that, second proviso has override the first proviso. That is the way of interpretation given by the council. Now, according to my submission, my lord, the second proviso only provides for giving opportunity of being heard. Now, the main provision is very clear: after inquiry, suspend or remove. Now, section 11 also, lordship, can you see page 21?
Yes.
My lord, annulment. The provision contained in the United Castle and the Hills Autumn District Council appointments and such act, my lord, as amended shall on or from the commencement of this act no longer be operative as far as the Hima Maram is
Now you mean to say the complaint was 2006?
2016.
16?
16. Oh. 2016. And I filed my shokos also at that time, point of time.
So that's the only point. They have decided that it's not necessary that go for Darbar Hima.
Yes, yes.
And that once a complaint is there, if the committee is competent to take up the complaint and hold an inquiry.
Yes.
That's the summons substance. Where's the impugn order?
Now the impugn order, lordship, can come. Page number 117. I'm sorry, man. Page number 113.
Where's the relevant part?
My lord, I may take lordship to the next page, page 114.
Yes.
Second paragraph, my lord. At this juncture, before we deal into the various complaints, we are obliged to first examine and limit our decision to whether, in terms of first proviso to Section 5 of the Act 2006, the Executive Committee is barred from entertaining a complaint against the CM without the complaint being brought first to the knowledge of the third party. For answering the first point, it would be important to minutely examine the provisions contained in first and second proviso to Section 5 of the Act. First proviso undisputed provides that any complaint against the same should first be brought to knowledge and notice of the Hima third party. Second proviso that the Executive Committee shall not remove or suspend the same from office unless he is given an opportunity of being heard. According to us, both the provisos are to be read harmoniously in conjunction and not in isolation, for unless we do so, a different meaning will arise, leading to a confusing state. The second proviso has in fact installed the prerogative authority of the Executive Committee to remove or suspend a CM from office after providing an opportunity of a hearing. The second proviso provides that in the event of any complaint against the CM, which prima facie disclosed and he has violated any of the terms and conditions of his appointment of Senate, or that he has lost the confidence of the majority of his electors, or he has been conducting himself in a manner derogatory to his office, or which may undermine the authorized counsel, or after inquiry suspend or remove him from office, which to our minds override the condition contained in first proviso. I have a grievance with him, my lord. The legislature of the District Council, in its wisdom, enacted 2006 and inserted the twin conditions contained in first and second proviso. The main understanding of a first proviso to Section 5 of the Act is that a complaint against the same be brought for the knowledge and notice of the Hima third party. Third party Hima is necessary to be made aware of any complaint against the same. The first proviso does not stipulate deliberation on action by the Hima third party, insofar as the complaint against the same is concerned. The plain reading of first proviso to Section 5 of the 2006 Act goes to show that third party Hima has no authority to examine, initiate any inquiry, or take any action in the manner mandated by second proviso, or even reject the same. Admittedly, first proviso is not superfluous, but the mechanism for third party Hima to know existence of complaint against the CM. For the record, first proviso to Section 5 is directory and not to be read otherwise. According to, my lord, may I come to it as a contradictory, my lord. May I come to another one for the page 115. The terms and conditions of appointment, my lord, in the middle lordship.
Yes.
Appointment of CM White Senate 1991 grounded under the Act of 1959. Ipso facto overshadow the Act of 2006. But this is I have taken specifically. Is it incorrect?
Yes, maybe there's some reasoning behind it with regard to the powers of the Darbar Hima, whether they can take up a complaint against the CM, giving knowledge. Yes, Mr. Kanta, anything to say?
This is a very important issue.
You kindly unmute yourself. Yes.
Yes, Your Lordship.
Yes.
This decision by the Executive Committee is a very detailed examination of the provision of law, first and second proviso.
Yes.
And And in view of the interpretation given by the committee that the first proviso is merely directory, in a meaning that only the knowledge of the Darbar Hima. Now, when we look at the job of the same, he is the chief of the Darbar, he is the chairman. It is his duty when there is a complaint that it should be brought to the knowledge of the Darbar. Now, it is not for the Darbar to adjudicate or to inquire or to do anything. And be that as it may, the finding is very clear that the same has been appointed under the 1959 Act. And the new Act came into existence only in 2006. Now, be that as it may, the duty of the same is that he should bring this knowledge of the Darbar Hima. It's not for adjudication or anything. Now, we have a prerogative authority to take action in the events of complaint. There is not only one complaint of 2016, there are several complaints. My colleague did not spell out the entire order passed by the EC. Be that as it may, this matter requires deliberation, and
we'll fix an admission hearing, and then we'll dispose it off on the admission hearing stage only.
2013 also, similar issue.
Yes,
case.
yes, Mr. Kenta will dispose admission hearing stage. Yes,
much obliged, Your Lordship.
Yes, I heard Mr. H.L. Changreso, the counsel for the petitioner, Mr. Vijay Kenta with MSc Nongklau, is present, accepts notice on behalf of respondents 1 to 4. Who is this number 6?
My lord, he's the complainant, my lord.
He's in SC. That notice issue to, then it'll take time then. Then let notice issue to respond number 6 also. Steps are taken in 3 days. Stop. The next paragraph, the writ petitioner is that the respondent executive committee deciding on the maintainability of the complaint has held that the proviso which enjoins that a complaint be first placed before the Darbar Hima is only directory and it's not mandatory. Stop. To this, Mr. H.L. Changreso, Senior Counsel, submits that the same is incorrect and has spread that you are asking any interim orders.
My lord, some protection will be given, otherwise they will proceed on merits.
While the matter is to adjudicated by this court, that the order dated
impute order, my lord,
2024 be suspended. Stop. Misgive. Next paragraph. The Vijay Kenta submits that the order impugned has been passed after thorough consideration in a detailed fashion by the executive committee, this council, and no interference is called for. However, submits that I don't know, he should give you a form. So, accordingly, he submitted no interim orders are called for. That's your submission. Stop.
Yes, Your Lordship.
Next paragraph. After hearing the counsel for the parties and looking at the nature of the case, it appears that the matter requires some hearing, especially on the interpretation of the provisos as given in the Act. What is the Act called?
Same Maharam, same ship.
Yes.
My lord, consider autonomous strict nomination in election of CM, deputy CM electors of Imam Maharam Act 2006.
Accordingly, this is matter after 2 weeks or 3 weeks for admission hearing. An endeavour shall be made to dispose of the matter at the admission hearing stage. Stop. Till the next date, the impugned order shall not be given effect to.
Yes. I do.
Affidavit can be filed also.
Yes.
Always a question of law, but a respondent at liberty to file affidavit if necessary.
Daily list, item number 1.
Done.
Your Lordship, the matter was settled, so only the formalities is yet to be done.
So we'll close it.
Yes.
Yes. Mr. Ilalu.
Yes.
Which submits that the matter has since been resolved. He prays that the same can be closed. Yes. Accordingly, on submission to the counsel petitioner, you are appearing for number 3?
Respondent number 3.
So you record his name. The matter stands closed. Yes. And it's accordingly disposed of.
Item number 2.
Please, Your Lordship.
Yes.
Your Lordship, we have already filed a rejoinder, Your Lordship.
Just now?
Yesterday, Your Lordship.
Yesterday, you've received a copy?
We received the copy, Your Lordship. There is only one point involved. Matter can be fixed for admission hearing. At that stage, it can be disposed. There is only one point of res judicata.
Even if this hearing also, there's no problem here also. Most hearings are adjourned.
As Your Lordship
Yes,
desire.
pleadings, parties submit pleadings complete this matter for hearing in the after 2 weeks. Yes. Will it be 2 weeks? You prepare it, yes.
Item number 3.
For the paying for respondents, SD.
May I please, Your Lordship?
And Raji, yes.
I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
How many times you've taken?
More than 4 times.
More than 4 times, then enough.
No, Your Lordship, because we have not received the instruction, Your Lordship, and now also they are having some election duties, so I humbly pray 2 weeks' time, Your Lordship. Final opportunity will be given, Your Lordship.
What elections they're having? District Council?
No, not District Council. They are having some duty, Your Lordship. Yes, Your Lordship, but some of the members, they are
Some
having...
members are campaigning.
Not campaigning, Your Lordship.
Then? Yes, we'll ask prayed for further 2 weeks' time granted. After you file it.
Yes, Your Lordship.
Item number 4.
We are for the petitioner in item number 4, Your Lordship. We'll file affidavit of service during the course of the day, Your Lordship.
On which one? 2 and 3. Yes. You file affidavit? No.
No, Your Lordship. I humbly pray 2 weeks' time, Your Lordship, in this matter also.
Yes, MS Rajaji prays and allowed 2 weeks further time for affidavit stuff. MS P. Sunar, correct?
Yes, Your Lordship.
Submits the affidavit service indicating service upon the respondents 2 and 3 be filed in the course of the day. Just after 2 weeks, yes.
Item number 5.
Yes, Your Lordship.
My lord, affidavit is ready, but we are waiting for a signature. Can you grant us 2-3 days, my lord, to file the affidavit?
Vijay Janaja prays for allowed further 1 week's time for affidavit. Just thereafter and so on. So.
Deeply obliged.
Item number 6.
We are appearing there for the government. The record is named.
7.
Yes, Mr. Dasgupta.
Yes, but I am appearing.
Oh.
But we file the rejoinder, my lord. My lord, Lordship will kindly see the short issue involved in this matter, my lord. Is that without registering a case under MMRD Act, my lord, and they are trying to auction the property, the seized vehicles, my lord. Now the provisions of MMRD Act are very clear, my lord. Section 21(4), only under the order of a court, my lord, the vehicles can be confiscated. But my matter can be disposed of by a short direction, matter. The state should register a case or file
No,
a...
the thing is that it hasn't gone before the special court. Special court being constituted on MMDR Act, now to deal all these mining problems.
My lord, they have to file the case, my lord. Then we'll go for Jimma, my lord. If they file a case, produce the vehicles, my lord, before the court, then we'll file a Jimma application, my lord. Without doing that, what they are doing, they are proceeding under Assam Land and Revenue Regulation, my lord, which is not even applicable in the state of Meghalaya, my lord.
Applicable in 3 wards of Shillong and revenue lands.
My lord, but it's from Reboy, my lord. My lord, may I just point out one thing, my lord? The Lordship kindly comes to page 43, my lord. These are the proceedings of the...
43 of?
Red petition, my lord. WPC 375.
Page 43.
Page 43, my lord. And my lord, I'll point out at page 44, my lord, the last paragraph at page 44. Yes. Sri F. Lalu, Environmental Engineer, Meghalaya Pollution Control Board, expressed that there is a need to find out the names of the owner of these seized items in order to cross-check with the list of violators that had already been sent to the NGT in the matter of Jitul Dekha case. To this respect, the member secretary suggested that since legal complaint would be filed by the DFO East Khasi Hills Reboy Division, therefore he may be requested to share the details with the committee as and when the cases are registered. So, my lord, it is evident, my lord, the cases have not been registered till now, my lord. And we are left without any remedy, my lord. And it's more than a year, my lord, the vehicles are seized. Lordships will appreciate, my lord, the vehicles lying idle for 1 year, my lord.
Are they still there or the only skeleton is there?
They're kept in some petrol pump, my lord, the state government not kept on. So, my lord, if you can register a case, produce.
How many vehicles or how many?
In one case, there are 2 excavators, my lord, and in one case, there is 1 dumper truck. There are 2 matters, my lord.
Yes, Mr. Shulai, what do you see in the affidavit?
This is your lordship. Lordship, this is a case, your lordship. What happened? There is an order of the NGT and the shaking.
Whatever it is, but you can't. You see, if anything has been done, is but due process. That's all.
Lordship, there is
we're not
an
saying
order
that you can't. We're not saying that you can't do it. You
There
can
is an
seize
order
it,
of the
you can
NGT,
auction
your
it,
lordship.
you
It had
done
been
in
seized,
number
your
of
lordship.
cases. Your court got interfered.
It had been seized, your lordship, and then now we are going to auction, your lordship.
No, but it's due process.
Lordship, kindly see, they don't have even the permission. Lordship, for the moment, if lordship kindly.
Let's see affidavit.
Lordship, before I come to the affidavit, if lordship kindly come to the writ petition, annexure 4 at page 36.
Annexure?
Annexure 4 at page 36. This articles, your lordship, had been leased to one Shrimati Rutaman Nongklau. She is not here before, your lordship. They have not made her a party.
Yes. Yes.
She does not have even a consent to operate from the State Pollution Board, your lordship. Then she filed a writ.
You written here that she has CTE?
No, that is already expired, long time back, your lordship. Already expired. They have admitted also in the application, your lordship.
Yes. What do you want to say?
Then she filed a writ petition, your lordship. She filed a writ petition, then withdrawn. As on the date when this article had been leased by the petitioner to this Shrimati Rutaman Nongbri, lordship, nobody is having that consent to operate. A permission from the State Pollution Control Board, your lordship. And in view of the order passed by the NGT, your lordship, in G2 case, your lordship.
What case?
G2 Deka case, your lordship. That, your lordship, will find it at page. Lordship will find it at Annexure 7 at page 43 of the writ application. That is second.
Annexure?
Annexure 7 at page 43, your lordship. Paragraph 2, your lordship, of the said meeting of the district level committee, your lordship.
Annexure 7. Caesar list?
No, this is the minutes of the meeting of the DLC, your lordship, constituted and in connection.
Yes.
The members secretary gave a brief account on constitution of the district level committee and the term of reference within which the committee is required to function. He stated that the committee was constituted by the Deputy Commissioner Riboy in response to one of the National Green Tribunal order dated 10 January 2022 that was passed in a matter of now disposed case or so-and-so G2 Deka versus Union of India. So, Lordship, we are complying, your lordship, with we have taken the action, your lordship, in pursuance to the direction passed by the NGT, your lordship.
My lordship, kindly see, my lord, the MMRD.
1 second.
What is that?
No, see, Mr. Shulai, their case is that fine, whatever it is, you might have orders of NGT, but
Lordship, there is be followed. Lordship, because that order of the NGT has not been enclosed, your lordship. If lordship permits, I'll bring it by an additional affidavit, because there is a clear direction in that order of the NGT, your lordship.
This is 21-4.
No, this, we are aware. I mean, whatever is the due process, we're not concerned about,
21-4.
If the law says you do like that, you do like that.
4A, 21-4 capital A.
Of the Act?
Of the Act.
Yes.
Any military tool, equipment, vehicle, or any other thing seized under subsection 4 shall be liable to be confiscated by an order of the court competent to take cognizance of the offence.
What about your pollution laws? What does it say?
Lordship, if they don't have the consent to operate.
What do they say your pollution laws about the materials that are seized in connection with some illegal operation?
Lordship, that I'll have to examine, Your Lordship.
This is the only provision, madam.
I'll have to examine. Let it come for admission hearing, Your Lordship, then I'll place.
Yes, the rejoinder you filed when?
We filed yesterday.
Yes, the rejoinder has been filed by the writ petitioners on this matter for revision hearing after 2 weeks.
Yeah, this week.
Yes.
In the second item, Your Lordship, it's clear that there is no consent to operate, Your Lordship. This is apparent from the writ petition itself, Your Lordship.
Madam, we have simply hired the vehicles, madam. They have all the power. They can hang the person who is doing the illegal mining, madam.
Yes. Next matter.
But the interim order.
Same, Your Lordship. It will come for admission hearing, Your Lordship.
Item number 9.
Whatever it is, if due process is there, take due processes on. We'll give that allowance for you to
because there is a clear direction of the NGT, Your Lordship.
But by your admission said that, that okay, fine, the Pollution Control Board has found that out, pursuant to that G2 Deka case, whatever, from what we saw just now from the minutes.
And beside that, Your Lordship,
under the waiting for DFO to file a formal complaint.
Direction of the, that I'll place, Your Lordship, before Your Lordship.
You place the order of the NGT also?
Lordship, yes. Oblige, Your Lordship.
Yes, Mr. Noklam.
I have filed my
it.
counter affidavit.
Yes, Mr. Kanta.
Yes, Your Lordship, I've sought dismissal of the writ petition on the ground that this is a matter to be governed by the civil court, not by a writ court. And be that as it may, the respondent number 2 is not a necessary party, neither a proper party, because Dorbar have got no intention or interest in the private dispute of writ petitioner and respondent number 1. That's my case.
Wait, please, Lordship. On this issue, Lordship, then the respondent number 2 may be struck off. As of at present, also, Lordship, they are having a harmonious relationship. So, as such, but the only allegations
So
in the issue.
when the relationship gets disharmonious at them against parties?
No, Lordship.
Then?
That not matter, but Your Lordship, this matter was taken on board as 227. For the reason that we have informed them of the brief facts, Your Lordship, here is that a judgment is already pronounced in my favor. No appeal was filed by the respondent number 1. Until institution.
That's by Mr. Noklam's client?
Yes.
You didn't file appeal?
We have filed, Lordship.
At first instance, Your Lordship, that judgment which was delivered on 3rd November 1992. She's the legal representative and the interest. Lordship. So the matter of which...
Are you seeking the relief against respondent number 2? But in this, it's 227 now. It's become a 227 application.
Very limited, Your Lordship.
Then?
However, Your Lordship, but striking off...
So you have claimed relief.
Converting to 260.
You're not party early proceedings. They were not party early proceedings also.
No.
Then let's take them off.
Yes, Lord.
With cost.
Mr. Vijay Kanta, the counsel respondent number 2 has prayed that the said respondent is not necessary inasmuch as it was never a party to the proceedings from which the grievance of the petition has arisen.
Yes.
On this submission, Mr. Lingdo accedes to the same and
Your Lordship, certain statements I've made with respect to the respondent number 2.
But no relief came against them.
Your Lordship, there's a common relief which I've paid for at
Let's see at para 5. At?
Point number 5, Lordship, at page 30, my relief.
Page number 13.
Yes, Lordship, on the petition. So, a command prayer against the respondents, Lordship, I've made relief. Certain statements which I've made, Your Lordship, against the respondent number 2.
What is... Oh yes, I know this case. But Mr. Kanta, at para 18, they made allegations against you, against your respondent.
I had filed a very petition challenging the maintainability.
Have you filed it?
On the ground.
It's been filed.
I have already, yes, I've already filed this on board. I pray that my petition be allowed and be considered, Your Lordship. The original submission of my colleague, the petitioner.
Then we score it out. You don't have objection to this application?
We have not filed. With Lordship, for the matter of concern in Lordship, the matter was taken on board as application 227.
So you take down this case number 20/2024 in WC 379. This application has been filed by the respondent number 2, Bridge Darbar Umsning Proper A, questioning the maintainability of the incident petition on the grounds that the dispute is between the petitioner respondent number 1 and is clear civil dispute of a plot of land situated in the applicant's village, that the applicant's village is no way involved in a private dispute regarding a said property, and that the applicant's village is neither authority to resolve or to do anything in the private party's dispute, inasmuch as it's neither a revenue authority or a registration or authority under the Indian Registration Act. Stop. Though the question, the challenge is to the maintainability of the writ petition, Mr. Vijayakanta at this stage submits that at least the respondent number 2 should be struck off from the array of parties in view of the grounds as made out in the application. Mr. S. Lingdo, counsel for the petitioner, has not filed any objection to the Elmer's case and submits today that at this stage, it submits that the respondent number 2 on his submission will be struck off from the array of parties. Accordingly, respondent number 2 struck off from the array of parties. This case stands according disposed of, yes. And then in the main case, in view of the order passed in the miss case number so and so, this one will struck off those parties. Yes. Now next, respondent 1 has since filed affidavit. When do you want to matter next? You want for rejoinder?
I've just received the affidavit, Lordship.
Yes. So file this matter of 2 weeks.
Let the matter be fixed for hearing.
Okay, let the matter. Yes, Mr. H. Clow, on behalf of one submit affidavit been filed, has since been filed. Mr. S. Lindo raised the matter for hearing, and he may be permitted to file a joinder in the meanwhile. Accordingly, it's a matter for hearing after 3 weeks. Yes.
Obliged.
Item number 10.
Please, Lordship. Your Lordship.
Yes.
With regards to respondent number 6, we have just received the status report yesterday. So we have the service affidavit is in the process of filing. Your Lordship. It's in the process of filing, Your Lordship.
They received. And with regard to number 1 and 5, number 1 to 5.
Lordship, I prefer some more time to file my affidavit, Lordship.
Lordship, I am appearing on behalf of respondents 7 to 10 and 13 to 15, Lordship.
Yes.
I pray for some more time.
Yes, MS A. counsel of the petitioner submits that status of service of notice of point number 6 has been received and prays that she allowed to file service report stuff. Mr. H. Karan, how much time are you praying?
Was it 2 weeks?
Only?
2 weeks.
Only 2 weeks.
Achha.
On behalf of 125 and Pradhan, on behalf of 7 to 10, we pray for allowed further 2 weeks time to file affidavit. 30 to 15. Is the outline.
Item 11.
Much obliged.
Lordship, I am
Yes.
appearing on behalf of the state respondents. We will be filing our affidavit in course of the day, Lordship.
Lordship, in this case, there is one application filed by one of the party saying that I am a Marwari Panchayat.
Yes.
To become a party.
Have you filed objection?
I filed my objections. The only issue is that whether the Marwari Panchayat is the necessary party or the proper party. So according to me, he is not the party at all in this case. He is neither a necessary party nor a proper party.
May it please your Lordship.
1 second, Mr. General. Yes.
May it please your Lordship.
Yes. Yes, what are you saying?
It is not a necessary party because this is the suit, the representation I filed on being aggrieved that the proposal submitted by the outgoing managing committee to the school authority, to the education department, it was not approved. The reason for not approving, I do not know till today. What is the reason for that not approving? No reason has been assigned till today by the departments. In the meantime, I filed a petition seeking directions that the authority may be directed to approve the list which I forwarded to the departments. And there was a earlier order, even one out of the order passed by these honorable courts. They're directing them to approve, they have approved, last managing committee. Now they came, they said, I am the sponsoring body. It is me who has to submit the proposal. Nobody can submit the proposal except the Marwari Panchayat. Lordship, here the case came up before the single bench in the year 2002. 2 years. A very interesting case. This is the judgment. It is cited in one of the cases in Madrasa. Recently, court has decided in Madrasa Ahmad Islam, saying same thing, that I am the sponsoring body. Only a sponsoring body can submit proposals, and that case decided. Very recently, the Supreme Court has decided this.
Which court? Supreme Court?
No, by this court only decided. This on 14/3/2024.
What case is it? What does it say?
No, the court has framed the question. The sponsoring body.
So which part is the relevant part? Are there so much case?
Actually, this the case of which they relied in this judgment. This is the judgment which I am referring it. WPC number 341 SS 2022. Actually, this judgment was overruled by the division bench. Set aside. So this is the judgment relied upon here in this case. The court did not agree. The court said no, there is nothing to show on the record that. So now my case first. I'll start the case of.
So why issuing this case then?
No, this is a.
What relevance does it have?
No, the relevance is that the court has come to the conclusion that there is no such instances or there is no such materials on record to show that
they were ever involved.
Involved in the committee. That is the reason. And here same thing happened here also.
They are not involved at any point of time.
Any point of time.
They just want to intrude now.
Include now.
Yes, Mr. Jindal, why you want to intrude? We have no role to play. We have no role to play.
Lordship, a lot of factual inaccuracies have been submitted in the affidavit and before my lord today. The affidavit, the objection which has been filed, my lord, going through the objection, we find that a few factual assertions which are completely untrue needs a response. We seek lordship's permission to file a small rejoinder.
Rejoinder in this case, come on, Mr. Jindal.
Lordship, because a lot of factual things are. Lordship, a lot of factual things are involved. In fact, the rejoinder is ready. If Lordship allows, we'll file it today itself. It's ready.
And this case also, Lordship, once Lordship was appeared in this case, 2012 3 GLT, Justice Waipai has decided the case, how they are a proper party or not. In case of Islamia High School, that judgment passed in the case of Islamia High School, but similar situation arose.
Let's see.
Whether they wanted to become a party, the court rejected. They said they are neither the necessary party nor the proper party.
Same thing, recommendation.
Recommendation, same thing. It talks about the domicile letter.
No, but I see the things that they want to impede themselves to show that something's happening in your school or something that apart from you're not claiming relief against them. Correct. You might be dominus litis, like you know that you are the master of your case, but if the other, why should you stop them from being impeded?
So Lordship, this is but this case is very different. This is
It's
much
different in the
better.
sense that you're not seeing
This
relief
case
against
is
them.
much better than the case which I cited.
Much better.
Because why in the single bench, the matter was decided in favor of Marwari Panchayat. Then there is a judgment cited in Madrasa, but it's into overruled in fact. But the appeal was filed before the division bench, and the division bench has passed an order saying that the Marwari Panchayat is nobody in this case. Yes, it's not the.
Lordship, if I can humbly.
If there's nobody, there'll remain nobody.
That's what this is judgment.
Lordship, if I can.
Actually, this is
Lordship, if I can humbly.
Yes, you file. The objection has been filed to the application. An objection has been filed on behalf of the Ponbo. Has been filed by the petitioner to the application for impediment. Mr. Jindal submits that as in the objection certain incorrect facts have been portrayed. He prays aloud 2 days' time to file a rejoinder to the same.
Then the interim order may be allowed to continue.
The matter will be taken up after 1 week. We'll dispose it of.
Because my case is based on the facts
Yes,
of the
of course,
judgment, single bench and division
your
bench.
case. Let us give them satisfaction.
Interim order.
Orders shall continue in the main case to the next stage.
Item number 12.
Yes.
Obliged.
Your Lordship, we have entered appearance.
Half of
Respondent 5.
Sora.
Yes, Your Lordship.
What's the matter about Mr. Changreso?
Madam, this relates to boundary disputes between the parties, madam, private respondents and me. Respondent number 4 yet to enter have taken
Who's number 4?
Number 4 is the my lord,
You are
another
appearing.
village.
No, I'm for the discount.
You are appearing for who's appearing number 4?
I'm appearing for respondent number 4, Lordship.
Aban job Imli.
Lordship.
We file affidavits. What's required today?
My lord, since they entered the appearance, if they
I
want
have
to
a
file
humble
short
submission.
affidavit, otherwise, my lord.
Yes.
Let me proceed. Whether they want to file affidavit.
Yes, before that, Your Lordship, I would like to have some submission, Your Lordship. This petition district, Your Lordship, has come up starting from 2017 itself. From 2017, all these 3 villages, Maupu, Laitdo, Umblai, along with Laitlingdop, they fall on the 3 right.
Different rights.
Yes. Right Laikul Laisan, Laitlingdop fall under that right. From 19 above, they have received their sanat from 1899. Right Laitdo fall under right Sora Majai, and they have received their sanat from the respondent number 5 from 1964. Right Katnreushnong, Umblai and Maupu fall under that right, and they have received their sanat right from 19,000 onwards. These right, Your Lordship, they fall under the right of the Hima Sora of the respondent.
I think you have to put it on affidavit. These things.
Let her put in it.
It's interesting.
Very interesting.
Because these villages all
this is the first time we have been heard
Basically
also.
what happened is that the CM of Sora has held that, in respect of these are right lands. These are right lands and they fall under the Hima Sora, who has the exclusive right over the land. And the headmen, they have the right only over the subjects. Now the district council has overturned that. He said no. Once a village is recognized, they have their own powers on how to function.
Well, usually the other way around.
The genesis of the
aim actually over the souls of the subjects and not the land.
Not the land. That's where the controversy arose. Now that this council has, by the impinge order, this council has clarified this issue. So no, the CM cannot impinge upon the rights of the villages.
Anyway, you file affidavit. What about number 4? You won't file.
We'll be filing it.
Yes, MS online has entered with soon has an appeal on behalf of respondent number 4. Number
5.
Number 5 and MS first right. MS Ajishila has an appeal number 4 and.
Your Lordship, this one point I would like to put.
Yes.
The order of the district council, the EC, we have just received only 4 weeks back. Only 4 weeks back. Only by oral submission, they asked us the genesis of these three villages, which we have given the genesis, which is in the form of a booklet. But then after that, they have stated that, and they have asked us under the Ilaka Act, Rule 5(1), to go, all these 3 villages to go back to this aim, and a proper adjudication can be
affidavit first. You put that on
but
record.
without a tribunal, they have just decided that.
That doesn't matter. You put that on record. Yes, MSGC has a tribunal number 4 and MS knowledge on behalf of respondent number 5 submitted by the respondent number 5 that you are opposing the decision to the council also.
Yes.
That means you agree with this.
It's a very confusing order.
Yes, also supports the case with petitioner.
No, we are not supporting them also, Your Lordship. That we have never been hurt.
Neither does respondent 5 support a case
They are
with
all our
petitioner,
subjects.
nor are they in favor of the impinging order. She prays for us allowed to file a deal affidavit, bring a record, whatever necessary materials. Number 4, similar prayer, 2 weeks time to all the parties. Yes, let's after 2 weeks. Yes. You file an affidavit. Interesting. Yes.
Very simple
Tomorrow
affidavit only.
Tomorrow shall continue the next day. Yes.
Item 13.
Apply, Your Lordship.
The affidavit, how long?
I'm praying for some more time.
3 weeks further time as prayed. Granted to the response affidavit. For you, I'll have to give some more time because 2 weeks doesn't seem to suffice.
14.
Yes.
Lordship, 3 weeks' time may be allowed, Your Lordship, for filing your affidavit. We've received the paralyzed comments.
But he discontinued the contractual appointment.
Yes, we have discontinued that.
MST Yangi prays for allowed 2 weeks for the time to file affidavit. There's a half term since. Hello.
Obliged.
Yes, Mr. P.T. Sangma.
Lordship, this is for payment of salary, Lordship. They have not been paid the salary to the staff, the municipal employee.
Office note indicates that notice not yet served upon 3 and 4.
3 and 4.
So, what about the affidavit? Not filing.
Not yet.
Stop like Sabaram, MS Sham, then it GF 1 and 2 submits that no affidavit forthcoming from the respondent. You're filing or no?
Your Honor, are we seeking some time?
You're seeing the file. I thought you were not filing. Praise funds out 2 weeks for the time to file affidavit. Just that after, for affidavit for service report on respondents number 3 and 4.
Hearing, supplementary list item number 6.
Is it correct?
Yes, it's identical matter. They continued for some time on the strength of the interim order passed by this.
Yes, Mr. S.U. Upadhyay had submitted that this case is covered by the judgment order dated 5/4/2024, passed WC number 291 of 2023. Next by Dr. T.N. Musica, and DSG Act respondents has also concurred the submission and that the matter stands covered. Accordingly, in terms of the judgment dated 5/4/2024 passed in WC number 291, it's only for a period of yes, sir.
Interim order during that period.
The respondents are directed to examine the aspect of payment of pay and allowances of the writ petitioner for the period he served after interim order was passed by this court. There is dismissal. The dismissal of what? The WC number? In this case?
WPC number 12 along with 59 other writ petitions.
No, this writ petitioner, when he filed, was dismissed.
He was also one of the petitioners.
What is
WPC number 60.
WPC number 60 or 2015 thereof. Matter accordingly stands closed and disposed of.
Daily list, item 18.
You filed in court. The copy.
No, Your Lordship, I did not file by the distributed. I just handed the copy.
My Lord, this matter has taken a different turn now, my Lord. My Lord, Your Lordship, kindly comes to the Constitution of India, my Lord.
Interesting. Constitution of India. Why?
My Lord, the Constitution 105th Amendment has given the power of declaring OBC to the state government, my Lord. Before that, my Lord, the Maratha reservation case was decided by Supreme Court in 2-3 years back, my Lord. Where,
not 2 years back, 2 years back.
So there Supreme Court decided, my Lord, the power to notify the list, even for states, is with the central government, my Lord. To overcome that, my Lord, the 105th Constitution Amendment has been carried out. Now it has sought to restore the previous position that state government will.
So Justice Morey's judgments are upheld by legislation. Justice Morey passed an order which was set aside by Supreme Court, the Maratha judgment. You're not aware of it, yes, anyway.
So, yes. My Lord, now the state is saying, my Lord, state is given a compilation, my Lord. If Your Lordship kindly turns to the...
Where's 105th Amendment? Is it here? Is it here? Oh, yes. But 105th Amendment came in 15/9/2021.
Yes, my Lord. आर्टिकल कौन सा?
It's come article.
See 42A, my Lord.
Mr. Jha,
My Lord.
Are you aware of this? Yes. Then why didn't you apprise the court earlier occasion?
My Lord, here also in the state government in the compilation, my Lord.
One second.
My Lord, interestingly, my Lord, in the compilation, you also will see the state has annexed a letter of 1979, my Lord.
The same.
Though it is not paginated, but it is somewhere in the middle, my Lord. This.
No, see, yes.
Also seen this 1979 letter is there in the compilation.
In the affidavit.
In the compilation
In the
given by the state.
compilation which has been handed over.
By whom?
By the state government.
Oh, okay. Where is that?
It's not paginated, my Lord. It's somewhere in the middle, my Lord. Up to around 10, 12 pages, my Lord.
The letter dated?
10th October 1979.
1979, my lord.
May I assist you, Lord, sir?
Annexure 9 of the same notification, my lord, the same notification which I have annexed in Annexure 9 of the writ petition, my lord.
The same one?
The same one.
Yes.
But this is 10th October 1979 from Under Secretary, Government of Meghalaya, Social Welfare Department to the Backward Classes Commission. It says, my lord, I am directed to refer to your telegram quoted above and to furnish as follows the list of other backward classes from the state government as desired for favor of your information and necessary action. Other backward classes, a provisional list of the communities belonging to the other backward classes for the purpose of granting educational facilities and other concession in this state is given below, issued under TAD number so and so of the Government of Assam, provisional list. Now it includes Ahom, Bania, Barui. There are two lists, my lord. And on the next page also, Rajbangshi and Koch are mentioned, my lord. So, my lord, now, my lord, after the constitutional amendment, state should act, my lord, to notify backward class in the state, my lord.
She 42 says, the President may, with respect to any concern, where is the state, after considering the governor, thereof public notification specify the socially and economically concerned. That means it's a big exercise the state has to do. So where is the leap with the Jazz case?
If list is notified by state now,
After,
and if she
after
falls in
5
that
years.
list, my lord, some retrospective consideration can be given to Mr. Jazz client.
My lord, the only problem that OBC, my lord, it's not the fault of the petitioner here. In
MS Nongkandri, you informed Advocate General to appear next year in this matter.
Yes, Your Lordship, this letter that they've referred to, the 1979 letter, Your Lordship, is a provisional list of the OBCs.
Yes, provisional. But now, in view of the constitutional amendment, take down in the course of hearing of the instant matter, which is regard to the recognition of the writ petitioner as a OBC in the state of Meghalaya, it has been brought to notice of the court by the Learned Senior Counsel on behalf of respondents that by constitutional amendment to Article Amendment Article 342A, capital A, has vested the power in the case of the state to specify the socially and educationally backward classes after consultations of the governor. Stop. As the matter has wide implications, the Advocate General, as one of them, MSZ Indogandi prays that the Advocate General may be asked to appear in the instant matter. And this is matter after 1 week.
2 weeks, my lord.
This is matter for 2 weeks, yes.
If
that's the case, then we'll give you concession. Maybe by the time she joins us, due to retire also, God knows.
19.
Diplo.
I praise your Lordship.
What notifications did you produce last time?
Last time I produced 2 notifications, my Lord. One is 1978, the other one is 1983, ma'am. This notification clearly suggests, my Lord, that the ad hoc service also will be counted for pension and other benefits, my Lord.
What happened in this case?
Lordship, in this matter, in earlier writ proceedings, Lordship, or the WPC 200 of 2021, Lordship, the pensionary benefits were already granted, Lordship, and matter was closed. But then in your Lordship's order, Lordship has stated that since with regards to the pensionary, with regards to amount in...
with regards to regularization.
regularization. Lordship, whereby he is seeking amount with regards to 2096 to...
From the date of appointment, my Lord, that is 1992, as an ad hoc
Lordship,
so during the pendency of the matter, my Lord...
were they regularized with respective effect from 1992?
No, it was regularized from 1/4/1996, my Lord.
Then 1/4/96 will be covered by the old pension scheme. You're seeking 93.
I'm seeking from 91, my Lord.
Lordship, can
92, my
I
Lord.
take your Lordships to paragraph 8 of the petition, Lordship? Lordship, may I read?
Yes.
As clarified above, is being submitted that the said order dated so and so.
Wait, para 8 you're reading.
Lordship,
What are you reading?
You're reading which paragraph? I don't know.
This is paragraph 8, right? I have the wrong petition.
You have the wrong petition.
Sorry.
What do you mean you got the wrong petition?
Lordship, I got the previous petition, Lordship. Sorry, my apologies.
Rely on some of the petition.
Is there on the list today?
No, no, my Lord.
No,
That has
Lordship,
already been disposed of. I think my Lord is relying on
I
that
took out the wrong...
Here my only contention is, my Lord, that...
No, we understand.
Lordship.
You're saying give me from the date realization to complete your pension from that time.
Lordship.
For the purpose of... Now the thing is that for the purpose of leave, then what do you call it, the other increments and all this has been already computed.
He's been already been discharged, my Lord. After an order which has fallen from this Lordship, my Lord. Pension and other benefits were...
Where's the order? In the next year? No.
They have enclosed, my Lord. Page 45, my Lord.
Mr. Kharavana, you bring the correct file.
Lordship, during my leave I misplaced it somewhere, Lordship, but then... Lordship, I have my
all your files also.
No, Lordship, I think it was mishandled. My apologies, Lordship. But then, Lordship, I have my counter with me, Lordship.
You prepare. You take it after 1 week. We'll dispose it of it.
Lordship.
That's the only contention.
That's the
That
only
you rely on that old 78 notification.
Lordship.
78 memorandum.
Because in their
FR 26A.
In the order also, my Lord, they are saying that they are inclined to only grant me benefit from the date of regularization, my Lord.
Well, that is the case.
But as per the notification, my Lord, it has to be granted from my service as an ad hoc employee should also be counted, my Lord. That is the notification is very much clear, my Lord. But they are not abiding by that notification itself, my Lord.
Understood, yes.
20.
Hello, brother.
This is a writ petition pertaining to the issue.
Lordship, yes, I'm ready, but Lordship, before my senior starts, I would like to bring your Lordship attention to section 7I, Lordship.
7I. What's in 7I? modification of the scheme?
No, Lordship, Provident Fund 7I, Provident.
What are you reading? 52 Act, correct?
Lordship, 7I of the Employees Provident Fund Act.
Yes.
7I, appeals to tribunal.
The scheme or the act reading?
Act.
Yeah, what does it say?
Appeal to tribunal. Appeal to tribunal.
Where is what you're reading from? Seven. Oh, I mean, sorry.
I.
I was thinking about 1. Yes, appeal, yes, 7I, yes.
Yes. Appeal to tribunal.
Yes.
Any person aggrieved by a notification issued by the central government or an order passed by the central government or any authority under the proviso to subsection 3 or subsection 4 or section 1 or section 3 or subsection 1 of section 7A or section 7B, except an order rejecting an application for review referred to in the subsection 5 thereof or section 7C or section 14B, may prefer an appeal to a tribunal against such notification or order.
Time limit?
A time limit is not there.
When does the order pass? Does orders pass against 7 and under?
Under 14B and 7.
14B and 7A.
7Q and 14.
Yes, Mr.
No, Lordship will see whether this is an order. This is an order under 14B and 7Q. 7Q, no appeal is provided.
7Q interest, 14B is.
Yes,
14B is damage.
Penalty.
84P,
14B penalty and
7Q. No, from 7Q, no appeal is provided to the tribunal. This is one thing, and second thing, my lord, this is the case. Because my only contention is this thing, the issues, the dues which were finally settled and paid at the intervention of the courts. And that should not have been revoked.
yes. So,
Lordship.
7Q is not covered by 7I.
7Q is not covered, but
Yes.
7Q is interest and
On the penalty, yes.
Yes, on the and 14B is the
Penalty.
penalty.
Yes.
So the main thing is decided is that 14B has they are interconnected. 7Q and 14B, they are both interconnected. It cannot be a case that one it's like same in one conviction is there that under the person is convicted in IPC, whereas the punishment prescribed, it is sometimes it is said that okay, for example forgery. Forgery of documents. Sometimes it is said that forgery of documents, it can be same as forged. So all the, means like my point of contention is that since both are interconnected, one cannot be decided with the
You have the
help.
authority that says that.
Lordship,
The 7Q is covered. Also, you can read 7Q into 7I.
Lordship, there are multiple. There are a lot
I'm
of.
aware that many appeals have been entertained by the Provident
Yes,
Fund
many
Delhi
appeals
regarding this.
Yes,
But
there-
whether you have the authority to say, because this first time I think the challenge has come. Because usually it happens that it's filed for tribunal.
Lordship, in Supreme Court also it has come up. It has been stated by Supreme Court, like for the tribunals and as well as the this is the judgment, but I have only one copy. This is the
You come prepared with the copies of the other side also at least.
I have only one because this
Because
one,
what? Because this matter has been adjourned time and time again.
the last para it is. Point number 3, I think. First page only, point number 3.
Yes. What does the judgment say?
The judgment is all about the 14B, application of 14B, and it is the admitted fact is that they have been, we cannot go, they are not denying that they have not paid the EPF. It is an admitted fact from their side. So
Whose side?
From the petitioner's side.
Okay, yes. No, what is the judgment? How? What application will it have to your case?
Lordship, here actually I'm, since your Lordship's query that 14B and 7Q, regarding that only I'm for the CJIT, going about the CJIT, that's what I'm stressing, that it is appellate from the CJIT. It is the order has come from appeal, as an appeal from the CJIT.
Okay. Yes, you need to say that section 14B is a main section.
Yes, main section.
Damages and penalty.
Yes.
So whatever that's 7Q is consequential.
Consequential.
So that is not necessary. So only that it's the fundamental provision which has levied damages or penalty that should be challenged only.
Yes.
So that remedy is open to tribunal. And 7Q is inconsequential because it is not a charging section, you can say.
Yes, it's not the charging section.
When you say that, you've seen the judgment, Mr. I don't know what limit application will have anyway.
Lordship will see here one more thing. The crux of the issue might not entire
It's different.
Entire thing is depending on a High Court's order. Now, can suppose Lordship, without admitting my lord, suppose I go to the tribunal. Now, can tribunal review the judgment of the High Court? The entire thing might not settled by the judgment of the High Court. Now, if this earlier judgment of the High Court had no bearing here, perhaps understandable, Your Lordship. But here the issue has been settled, pursuant to the direction passed by this order, amount has been paid. Now, could they have reopened? So if I go before the tribunal, again tribunal will have to, my lord, go into the High Court's order.
No, you're right, of course. Because this stands on different footing. It's not a clear cut that these people are covered by the Provident Fund, the Provident Fund is not paid, there's 14B has been given, you dispute the assessment. That is a cut and dry thing. You go to the tribunal against the assessment done by the foreign authorities. In this case, where's the High Court order? You pay the 25%
Yes,
contempt.
all those
Then
things
what do you want now?
How you have reopened?
Where's the impugned order?
Lordship order is last, my lord, page 84. 84, 85.
For the same period?
This period also covered. My grievance is only this period. You could not have touched this period, to reopen this period.
Period from 1097 to 4/2007?
Yes.
It's 10 years. Where's the period reflected in the judgment? Is that reflected anywhere?
Lordship, period.
The period, yes.
But that's why I think briefly, if I can place the facts, my lord, I can start it. Otherwise, there will be confusion, your lordships. Now, my lord, if I can take my lords to Character 5, man. Page 56.
Yes.
This is the earlier notice, my lord.
This is
The
the
earliest notice, my lord.
is dated?
Dated, my lord, 9/12/2004.
Against this you came?
Against this, my lord, the earlier round of litigation, my lord. My lord, if your lordship, the time
Where
next.
can you show that, Mr. Sen,
Lordship.
that you know that the reduction in the interest which is allowed by this court covers the period in question that
Yes.
that you know they went for second inquiry?
Yes.
You have to show that only.
Yes,
If that period is covered, then
Lordship will kindly come to page 60. Type copy is 60, my lord.
Yes.
Now, my lord, lordship will come to paragraph 3.
Yes.
On consideration, subparagraph, my lord. Subparagraph under paragraph 3. On consideration of the record placed before me and submission made by the authorized representation, the employer during the inquiry of the light and finding, I have reason to affirm that the employer failed to remit the dues of BPF, annexation, and respective funds before the due dates in respect of the dues for the period from sections 88 to 2001. As shown in the certified schedule penalties without valid reason, the total amount, interest, damage payable in respect of the payable amount for the period ended 81 to 2001. Now, this is what they have calculated, your lordships.
Yeah, but only for March 98 2001.
Yes.
So other periods are not there. You said
No,
1097.
that is what other periods could not have been segregated, your lordship. That's why I entered the challenge. Because I am concerned only with that has been covered by
Now what's covered in judgments only March 88 to June 2001,
Yes, sir.
which it was the amount shown in the earlier petition, that's 7,36,000.
Lordship.
For which 25.
Now they have again, my lord, reassessed for that period also. Now a segregation, because this question was asked by my lord initially also. Now why not segregate? It cannot be segregated.
Why can it be segregated?
No, my lord, this, lordship will, that's why I will take the lordship to the impugned order. Now, my lord, so this was the period, my lord, 88 to 2000, June 2001, your lordship, which was challenged before this honorable
Now impugned order says which period? Let's see.
Lordship, the impugned order is at page 70, my lord, annexure 10.
80, not 84. Okay, 70.
Lordship. Now, my lord, this is dated, well, this was issued on 15/12/2021. 2021.
Yes.
Now, my lord, for the period, my lord, period they have mentioned, your lordship kindly come, my lord, after the table, immediately after the table, my lord. Now, the scrutiny of the records maintained by this office for the remittances made by you during the period from 1/4/96 to 31/3/2014. That was subsequently corrected, my lord. Actually, it should have been, my lord, 10/97 to April 2007. They have corrected subsequently. So this is
where have corrected subsequently.
Lordship, if I can take my lord.
31/3/2014.
Yes. If your lordship come to Annex 11, page 75.
Yes.
Now that letter has clearly mentioned, my lord, in course of inquiry, the period of inquiry 10/97 to 4/2007. In the bottom. And this is reflected also ultimately in the impugn order, also final order.
No, fine. 10/97 2000. But your case only that March 98 2001 is covered.
Yes,
that's
covered.
over.
It could not have been. And there is no possibility of segregating it. Now, what I am praying before this.
No segregation. Why can't you segregate? Now, if for this period 88,001, you were slapped with a levy of 7,36,000, correct?
Right. No, Lordship, can
88,001. That's correct. 1988 to 2001.
Lordship, the previous one.
This previous case was March 1988 to June 2001.
2001. But Lordship, if Lordship, Lordship, I can draw attention to page 53, Lordship. Page 53, Lordship. Here, the table says. It's if I can draw Lordship attention to a table, 1998 is there, Lordship. Page 53, Lordship. Then directly it has come to 2001. It's not the table itself is very much clear, Lordship. On what are the months we have.
So you already cut that period out.
Yes, Lordship.
It's 88 or 98 or 98.
It is not. It cannot. It is not just whole period. We have already. In our tables we have already segregated which are the months they are penalized.
One second. Let us be clear.
You were looking to page 63, where the
one second.
impugn order was
confusing the court now.
No, 63. Lordship will come, things are very clear. When they have imposed the penalty and other thing, they have again mentioned the period. 63. Page 63, my lord. In the table, the amount they have calculated, accordingly. Period, they have mentioned 388 to 6/2001. This is the period.
Where page 63?
Page 63. This is the impugn order, demand notice. 388 period from 388 to 6/2000.
But if you have left out 10 years then?
Lordship, what I have drawn your Lordship attention, that table, Lordship, it is not a case that we have calculated for the entire period.
These foreign fund cases not on law or it's just on number crunching. That's why I don't like doing these cases. It's just that, now which year, now you assess.
We have assessed, we have already, these are the matter, that is why the tribunal.
See, you're showing this at page 53, you're saying that, see, the 198 to 2001.
198 payable at 15 to 1998.
Okay, up to
then
2001.
directly we have come, in the middle there is no calculation.
So 98,001. But his case is that from 88 was the whole assessment.
Lordship, the assessment is based on the calculation, Lordship?
No. Now
the table.
The petitioner's case is that if from 88
Lordship,
2001,
yes,
that
Lordship.
period, they've already challenged it, it's water under the bridge. Now your new notice it can be from 2001 onwards, but you have clubbed it from 97 again.
Lordship,
You start
those
from
are
page
the
652, 97 to 2001.
Lordship, it is 97, but Lordship, according to the table, the recent table, it is not here, Lordship, but according to the table, Lordship, we have not calculated what we have already assessed in our previous notice. In our new notice, that we have not calculated. The escape period, it is under 7A, Lordship, determination of money dues from the employee for the escape period. That escape period can be calculated on later stage, Lordship, if they are not paying of that. Because the case is determined based on the table, what we have assessed.
But the thing is that, see, what has happened in this case is not a question of determining the assessment year, a question that the High Court, they come before the High Court, before this court rather, for a certain period, correct?
For a certain
his
period,
case is that, for that period we've been given this kind of relief. But by you impugn order again, that period for which relief has been given, that means 88 to 2001, has been included. That's all.
Lordship.
And your case is that no, but from your table it shows that you only exempted 98 to 2001, that's 3 years.
Lordship, it's not only that, Lordship, all the tables, Lordship, entire, the table it is showing. How we have come to the conclusion that this is the amount? According to the table, Lordship. So the main proceedings is based on the table. That this is the assessed amount based on the table. That for this month, his penalty dues is this. For this month, for January, this much. For February, this much. So part day delay is also interest is calculated. So based on the table, we have come to the conclusion on High Court's judgment. But
no, now we come to impugn order issue 10. Yes. Now scrutiny shows that during 1996 to 2014. Now you given the whole blanket period, 2014, and you say that is wrong, and you come to where that page. Now you say that the period of inquiry is 1097 to 2007. Period of inquiry, a period of, see, Mr. Sen, period of inquiry, and and for the remittances, that's made that period totally different thing. They have done an inquiry fine from 497 to 2007. Okay, they have done an inquiry. Well and good, it's 10 years inquiry they have done. That is the inquiry for which they have, generated these remittances, which according to them is a shortfall. But your case comes in the middle that, with regard to entire assessment, is wrong. For your entire period of inquiry is wrong, not a period of remittances, because for the period 88 to 2001, I'm covered by the judgment passed by this court. So your case is that their period of inquiry should have excluded that particular period. That's all, if I answer correctly. Yes. Correct?
Lordship.
Other thing I have said
is that, see, if you are free to conduct your inquiry. But the thing is that his case is that, if I understand correctly, is that you have conducted inquiry for periods which should be already been left out. Yes. Now your table you're showing, it shows 98 fine. It is the assessment on remittances that should been made. When is the due and when is the due date, and you have not paid payment, fine. Then for you pay penalty for late payment, you interest on the penalty, damages, so on and so forth. That is well and good. That's the only thing.
Lordship, here the thing is that we, according to the according to our order, page 85, last part.
Yes.
Page number 2 of the order. The submission made by the employer. Lordship?
Yes.
Yeah, submission made by the employer has been examined with reference to the materials on record, rule, position, and the law laid down in this regard, and it has been found that for the wage month of 1097, it can be seen from the challan submitted.
We understand that. See, the thing should be clear. They should know where they stand. Now you say that, okay, the period up to 497, if the escape amounts, like, which are after that period, we understand, but it should be clear. It shouldn't be so convoluted.
Lordship, we have given them the same the same table which we have assessed.
Why you make it so complicated then? Why should you make it very clear? This is an order to reconcile the accounts, so on and so forth. Order was passed by the court and so and so. So those amounts, that will be out. But that is an escape, some escape amounts are there for a period from maybe 1097 to so and so. then so that's why assessments done accordingly. The period of inquiry we've done from 497 to 1097 to 4007, but we have consciously left out a part because covered by the judgment. Why can't it be so simple? Why do you make it so complicated?
Lordship, page number 72, Lordship.
No, why do you make it so complicated that for the common man it becomes like reading Greek and Latin to understand notice also?
My lord, the other point I have taken, my lord, escape amount. I'll just refer to this. Escape amount, my lord, yes, they can reopen,
of course,
but not after 5 years. I'll rely on the after 5 years categorically barred, my lord. Now they cannot say there is an escape amount. I'll rely on that.
Lordship, page number 72, Lordship.
Yes.
Page number 72, Lordship. We have categorically, Lordship, we have placed all the evidences that this is the month which they are supposed to pay and what is the amount of delay. First page is first column is 1997. They paid, but it is in 2004. They paid, but it is in 2004. So the delay is counted, Lordship. Then again.
No, then why didn't it come up when the matter was here before this court in the first round? If this period is covered by the same, it's covered by the same period of inquiry.
Lordship.
From that 88 to 2001.
Lordship, it is. It is.
That is what. See, if the 15/11/97 is the due date, right?
Due date.
2004. Now this 97 period is already covered under the thing. So you think these escape amounts for late remittances? What is your argument?
Lordship, the late remittances, it can. It is charge. The interest is charged on the
I think
late.
you have to make a small note for me. It's become Greek and Latin. I'm trying to simplify the whole thing, but it's getting more and more complicated.
Lordship, I'll
you understand
Lordship,
what the court wants? The court only says that, fine, your period of inquiry as per your own records show that you entered to do the inquiry was for 10 years, correct?
Lordship.
And in your inquiry of, like any exercise of inquiry for 10 years, these things have come up, correct? And so your table is based on an inquiry also that there was late payments, so on and so forth, the escape amounts, so on and so forth, which you're trying to reconcile and recover,
Lordship.
right? And that is why you've given them the impugn notice again that these amounts have to be recovered for these periods. But then there's no clarity with regard to what happened for the period which, it's already been, they already challenged. And orders of the court said, fine, the penalties reduced, the damages or interest, reduced from 100% to 25%. That's the only relief they got. And they say for those amounts, that was 7,36,000 something assessed at that point of time, they've paid the amount.
They have paid, but based on the table, Lordship.
Exactly.
Based on the table.
Based on the table now, court can't understand also. See, we understand the process, but it's logically it should come up, You make a note, make it simple. Even this one authority should make it simple also. They should go for some sort of, what do you call it? Unlearning process is called. Because you don't even go for learning only. Sometimes you have courses for unlearning what you've learned, to unlearn to make things simpler. Because this is the way you find the table is fine, but the orders are so complicated that people don't know. It's not the only case. They don't know where they're standing also. Whether they're due to get money or they have to pay money, or the accounts get frozen. They don't understand why the accounts get frozen also. Right? Or maybe they like to shroud this and all this, kind of. This all this complicacies so that SSCs have no chance, to run here and there.
No, Lordship, it's not the case. We are thinking about the beneficiaries also, Lordship.
Of course,
because ultimately the beneficiary suffers.
This is socially
Social security is provided to the
beneficial act. ESI, Provident Fund, all socially beneficial. It should go to everybody. But only thing in assessment, like why this course saying unlearn. It's unlearn, like when you pass impugn orders also, orders, they should be, for a person who's not trained, to understand it. They don't have to go to a chartered accountant and pay him just to decipher one letter.
Lordship, the thing is that
I understand your arguments totally with regard to why this amount you're trying to lie on the table. But then I wanted to
for
have
that
like,
purpose only, Lordship, it is for that purpose, because it becomes sometimes it becomes part of evidence also. That is why the appeal has been preferred as a tribunal.
That's on bona fide. That's bona fide grounds. Yes, you can go for appeal. You
Appeal
feel the
is-
amount is
yes.
wrong, or maybe some miscalculation among employees, so on and so forth. That's different. But I'm talking about the method. You see.
On last occasions also,
If we given them a notice again, or assessment, whatever, your order under 14B or under 7A or under 7Q, if given in clear terms that for that period so and so it's out, and so on, it's just a small exercise.
Lordship, we have heard them, Lordship. On our daily orders, we have reflected, we have heard them on each and every occasions for which they have already paid the challans. That is why I have said, I have mentioned, Lordship, in page number 85, Lordship, that the previous damages, regarding the previous damage notice also we have taken into account, Lordship. For the wage month.
The only thing is that
we have taken into account.
The only thing is that the court confused with the order of assessment. That's all. That's the only thing with what happened at period which they claim they should not be assessing longer. And now your stand is that because they made late payments, that is discovered afterwards, so you have the power to recover that amount also.
Lordship, 7A.
7C, my lord, regarding the escape amount, my lord. Lordship, can you see 7C, my lord, determination of escape amount, 7C.
Yes.
Where an order determining the amount due from an employer under section 7A, section B has been passed, and if the officer has passed the order, A, has reason to believe that by reason of omission or failure on part of the employer to make any document or report available or disclose fully or truly all material facts necessary for determining the correct amount due from the employer, any amount so due from such employer for any such period has escaped his notice. B, has, in consequence of information in his possession, reason to believe that any amount to be determined under 7A or 7B has escaped from this determination for any period, notwithstanding that there has been no omission or failure as mentioned in clause A on part of the employer. Now what he can do, he may within a period of 5 years from the date of communication of the order passed under 7A or 7B, reopen the case and pass appropriate order. Now all these things were settled way back in 2005. Now these impugn notice issued in 2021.
This is particularly to 7A and 7B. 7A and 7B, not 7Q or 14B. This is particularly to 7A and 7B. No, consequential to 7Q.
Make a note. Just put it in the what do you call it in a matter that's called understand also with regard to your inquiry and why assessment is done. Just make a small note. So I'm finding it very hard to understand. I cannot reconcile my mind also as to how you have the other periods which should not be taken consideration have appeared again in your assessment order.
7A is much more clear, Lordship. But it is with regard to 7A. The order has to be passed with 7A and 7B, not 7Q and 14B. What my learned senior is saying, it's with regard to 7A and 7B, not with 7Q and 14B. Now, the thing is that escaped amount can be measured if it has no... in our previous notice, that is why we have already reflected in our order sheet, that in the previous notice, whatever we have missed out, that can come into...
You make a note with regard to this amount which, with reference to the order of this court, as to why what has been delayed, what has been adjudicated for this court, that is over and above that this assessment has been generated. That's all. Can you do that or no?
Lordship.
You can't.
Lordship, I'll take instruction and I'll take the help from
instruction. This is as per your submissions today. This from your own genius, not from any instructions. If you ask them instruction, they'll make it more complicated.
Okay.
As per your understanding, what you're submitting now.
Okay, Lordship.
You make a note.
Lordship.
And you remember that the order of the court is there. So how you relate it to that order, and how the order will not have an effect on the assessment that's been given, that's being challenged by them now.
Lordship.
You have to assist the court. You understand? It's not written argument, just assist the court, yes.
Lordship.
This is matter of further hearing after 2 weeks, yes. Will you be ready in 2 weeks?
Lordship, 3 weeks. 3 weeks, Lordship, because 18th also I have one matter in Guwahati, so I'll be...
No, very busy counsel, okay. Okay, 3 weeks.
24.
That's the only thing, can't reconcile it. In my mind, I can't reconcile it. That's the only thing. Another one, yes.
Lordship, here I have already submitted my calculations.
Yes.
Lordship, Lordship can come to order dated 29/2023. 20th of September 2023.
Yes. Yes.
Lordship, all they have given us is a for example calculation. We have been requesting them since the time we received the notice, at least give us the name, the unique ID of the people against whom you are putting the penalty upon us to cross-check. They have not.
Lordship,
Lordship comes to page 44 and 45 of my petition, Lordship.
Yes.
Lordship, this is the calculation they have given us. Now, we do not know this computer generated paper is in respect of how many employees, whether they were continuing to serve from 93 till 2007, or some of them retired, resigned, expired.
No, they won't do the assessment. This is for them only that it's for the month of 93. It was presented on 15/2 and you paid on 2003.
Lordship, it was in respect of how, no, Lordship, this recovery has been done from us in 2021. This served us the notice in 23, they have done it.
Correct, Mr. Nair, but the thing is that even, the employee is not augured by them. The moment that list comes, the same thing runs, is right?
Lordship.
Lordship, the same thing runs. Lordship, we are not a profit-making institution.
Of course, but then that's the way they operate.
And prior to receiving...
They're not, it's not incumbent upon them to provide you the list of employees against whom. For them, just assessment, as per, they must have done inspection once, how many employees are there, and the same thing is carried on all the time, correct?
Lordship, once the employees, list of employees is submitted, the employer submits the payment. Based on that, the employee who comes with who comes to claim their amount with the employee ID and that code, we used to grant.
Lordship, the irony is that between 2011 and 2013, they served us a notice for certain backlog payments. We cleared those.
But not for the earlier ones.
But not for the earlier ones. Now they send us in 2021 for a period which they claim is from 1993 to 2006. And based on that, Lordship, then they have imposed the penalty and interest on us.
And recovered amounts also?
Lordship, they have. Debited from our accounts.
Lordship, if they have much more grievances, then they have to go for appeal, Lordship, because as per the Lordship's order, we have already given them the calculations. This is, for example, calculation, obviously, Lordship, because for each...
Lordship, 14...
14B and 7Q, Lordship, same, 7I.
When it very categorically reads that they will give me an opportunity to present my case. I have repeatedly asked them, please give me the details and the documents based on which you are imposing this notice upon me for recovery, so that I can argue my case, since we do not hold the records. And they have not given me.
Lordship, I have already provided the challans which we received, Lordship, in previous.
These ones?
Lordship.
What are these challans?
The challans, it does not disclose anything, Lordship. The challan says July 2003, Lordship, regarding payment is made on 23 September. So obviously, Lordship, the damage will be calculated, Lordship, interest will be calculated, and they are paying 36,000. So further, we don't have, Lordship. Then in August 2003, they have paid in again September 2003. Then cumulative, they have paid 92 to 2001. Cumulatively, they paid in 2003.
This is for the month 1092.
1092 to 401.
And the notice of claim is from 93. 93, Lordship.
When do you pay this one?
No, it is delayed, Lordship. We are not saying that they have not paid. It is on delay payment. It is not on not payment. It is on interest that they have paid. They have paid, but it is delayed.
Your entire case is there. On delayed payments only.
On delayed payments.
He is nodding very much. He's an expert provident fund.
Lordship, we have prayed from them, we have prayed through this writ also that we want the documents on which they have based these amounts. That they have failed to produce.
Yes.
And Lordship, once we know the
Another thing in your case that you could not, for the earlier periods which you say you paid, you could not, give any documentary, whatever.
Lordship,
evidence.
Lordship, page 62.
These provident fund cases are getting nowhere. This is a number crunching, yes. No law involved. It's just.
Lordship.
Yes.
Lordship, page 62.
Yes.
In September 2016, we had filed an FIR of certain of our records going missing.
Yes.
On record, this FIR was filed 5 years prior to us receiving the notice, so it's not an afterthought. Lordship.
Is there any mechanism to suppose in such cases to reconcile amounts from the amount that's paid earlier on? Suppose for that period don't have documents anymore.
Lordship, the documents, Lordship, actually they have provided the documents. They have provided the list. The employees, they have their codes. So once the code is there, the employees, they are the amount is deducted automatically, the 12%. So unless and until employee gets retired, that 12% wouldn't be deducted. So obviously everything lies on them only. Up to how the means how 12% will be deducted on the salary. So once the employee is retired, the salary is not there, so 12% will not be deducted. So it is.
Yes.
Lordship, there have been instances where the interest amount has been reduced substantially.
Yes. There are 2-3 cases by this court itself. Yes. Yeah, because the problem here is asking for refund, no?
Lordship, we have also made submissions in our pleadings, and that there has to be an onus on them also for coming after a period of over 2 decades. When in between this period, they have already served us a notice.
You have any authorities on that?
Lordship.
You have authorities?
Lordship.
You kindly show it regarding the delayed demand.
There is no limitation, Lordship.
Lordship, page 12. It's a compilation of 3 judgments, Lordship. Compilation, page 12. Para 25, Lordship.
Yes.
If I may.
Yes.
The Gujarat High Court in Gandhidham and Manufacturing Company Limited versus RPF Commissioner laid down a principle that prejudice on account of delay could arise if it was proved that it was irrevocable. There it was observed that for purposes of section 14b, there is no period of limitation prescribed, and that for any negligence on that part of the department in taking the proceedings, the employees who are third parties cannot suffer. It was observed.
Yes.
The only question would really survive is the one whether on the facts and circumstances of a given case the show cause notice issued after lapse of time can be said to be issued beyond reasonable time. The test whether lapse of time is reasonable or not will depend upon the further fact whether the employer in the meantime has changed his position to his detriment and is likely to be irrevocably prejudiced by the belated issuance of such a show cause notice. It was also stated that such a defense of irrevocable prejudice on account of delay was to be pleaded and proved in the reply to the show cause notice. Lordship, para 26 goes on. Lordship, this judgment has been relied upon by the 2 subsequent judgments in the compilation, and the interest has been reduced substantially, Lordship, which was levied. Even in our writ petition, Lordship, we have not said that we are not liable to pay or we are liable to. We have said.
What amount of interest you have paid?
Lordship, we have paid 5,49,277, and the penal damages they have 13,60,185.
But that's been the line, no? The reducing to 25%. That's the only thing. So this case also, even this other case, is that the period ending July 76 notice has been issued 87.
Ashok, in our case, the period is from 1993 till 1st of 2006, and they issued us the notice in 2021. And between this period, they have issued us another notice, with which we have complied and we have paid.
Now, what is your, when the show cause given appeared for them, what was your reason given? Like now the situation has changed to your detriment, that that you're not in a position to satisfy these amounts.
Lordship,
so the only thing that he said, all the documents are lost.
Lordship, we had also stated that the period of after which you are asking us to pay, and in the middle you have already asked us for an amount that was between 2011 to 2013, and we have paid. Now you have come up with you have slapped us a show cause notice for a period between 1993 to 2006 in 2021, and after already issuing us another notice for a period after 2006, and we do not possess the records because of the reasons which we have stated, and we requested them that in order to enable us to present our case or argue,
Give us the records.
Provide us the records on which you have based this show cause. They have given us a show cause. It has to be based upon certain records. So we requested them to provide us those records. They did not provide us. Then they have not provided us now.
Then in the last order, what did it say? What did he say about that? Let's see your request.
Lordship, page 72 is the order, impugned order.
Yes.
Lordship, page 73, our contentions are recorded in the order.
Yes.
It says the contentions made by the establishment is being summarized as under. That the assessment of the damage period traces back to the year 1993, and as such the school is unable to produce the relevant records from such old period to substantiate the calculation of damages issued to the establishment. The old financial records pertaining to the period of inquiry are no longer available with the school, and FIR was also filed by school in this regard after the new management took charge on 24/8/2011. That the EPFO office may furnish records based on which the damage calculations were done. Then they go on, Lordship, and they reject our contention.
You say no document is submitted.
Lordship, they say the submission made by the employer has been examined with reference to the material on record, rule position, and the laws laid down in this regard, and it is stated that 1. The present inquiry pertains to the delay in payment of PF dues by the school within the stipulated time, and the present management of the school cannot escape the penalty imposed for the delay in the payment of PF dues for the inquiry period. Now, Lordship, we never wanted to escape. Back then we don't want to escape. In fact, they have debited the amount. Now, all we asked was to please give us the records based on which you have come up with this amount calculation, Lordship.
Lordship, the thing is that they have paid, Lordship. Our main notice is that they have paid. The payment is
Delayed. There's only delay.
So obviously, Lordship, if 12% is deducted from the salary of the employee, then they have the employee's record with them. They have paid. We are not denying that they have not paid. That they have paid, but they have delayed.
Lordship,
but why did you serve the notice after so many years then?
17 years, Lordship.
Lordship, there is no limitation, Lordship.
So Lordship, explanation, you mean?
Huh?
No limitation, yes, because
There
it
is
should
no-
not be to detriment of the employees also, because it's their right. But the thing is that
And Lordship, it is the employees who are the beneficiary. It is beneficiary's right.
exactly.
This security, social security is provided. So obviously, it's-
Lordship, in such scenario, they could have asked us after 50, 80 years. If there is no there has to be a rational.
Yes.
Lordship, here the
So
employees.
they have it damages on 19 lakhs.
Lordship, based on two components, principal also being the penalty amount.
Penalty and interest. I mean,
Interest,
it's
Lordship.
14 lakh, 19 lakhs.
Lordship.
But Mr. Nair, there's no question of refund.
Lordship, at least the penalty can be.
Penalty?
The interest amount on the penalty. Because, Lordship, we are not a profit-making institution. This money will go into society building of.
Will you refund?
There is no provision, Lordship.
So they don't have a period of limitation. They don't have a.
Lordship, it is the Lordship, the penalty and the interest is charged to make the employer aware about that they should not be. They should not be, because ultimately the beneficiary suffers, Lordship.
No, for them the only grievance is that without proper reasoning, without delayed notice or delayed payments, you're not given them
Then
notice.
this is a fit
And so
case
that
to
is-
go for appeal, Lordship. Lordship, this is a fit case to go for appeal because if they are...
We go for appeal, Mr. Nehra. Because on regard to refund, only they can do it themselves. We can't set a precedent also that way. With only if you hadn't paid the amount, then maybe we can stop that your payment of the entire interest amount. Even suppose your case deserves it. You take a call, otherwise you'll pass orders.
I'll seek instruction also and can come
because
up.
What he's saying also has some validity regarding that this undue delay. There has to be they also must be taught, not taught, I mean shown. That you can't just because of limitation doesn't mean that at your whims and caprices you can do anything. And though it's a very draconian law, provident fund, because for recovery also there are other modes of recovery, but they go to the extreme method of recovery by freezing the account straight away.
No, we have not
done in most
freezed.
cases.
We
I
have
don't
not
understand why.
freezed the account.
I mean, you don't give them a chance also, to they just straight away they freeze the accounts.
We have not, in this case, we have not freezed the account.
Or
We have just...
gone to the bank and taken it out. That's happened in many cases. Anyway, we take instructions. Yes, in the course of hearing, yes, MSP Vartaji has submitted that the writ petitioner, if for the grievances as contained in petition, is at liberty to approach a tribunal, as the issue concerns only on the delayed notices for which they have been penalized. So Mr. N. Khera for the petitioner submits that he may be allowed to prisoner to obtain instructions. Otherwise, for refund, delayed is unnecessarily delayed. 17 years is
26?
everything has to be reasonable.
17 years also is from the outer limit, from the ending part of 2006.
We saw that, yes.
If we go back to 93, Lordship, it's 30 almost.
How, if we are a computerized system, how do the detectives after so long? Now you don't pay income tax, you don't file the returns. All your, one, Mr. Narana know very well, must have many accounts. If one money goes one account or account, he'll get a notice. They have noticed, this unnatural movement of money between these two accounts. What have you done? It comes within 1 week.
Lordship, our argument is, Lordship, in the same line.
Yes.
We are saying, if after 30 years, 27 from 1993, Lordship, it is 28 years. If after 28 years you have served us this notice for recovery, that means you have certain records based on which you have done it.
No, the thing that they have, only thing that is they are not so, what do you call it, alert.
Lordship.
In income tax, you know what happens. I mean, even suppose they give me notice after 3 years that there was a movement of money, some transfer you've done. What is it for? Notice is gone. That's after 3-4 years, and it goes for 8-7 years. They won't do that. It comes immediately before you file your next returns. That there's a movement of money you have to explain.
Lordship, in the IT laws also, Income Tax Act, now they have put a bar limitation that beyond these many years you cannot come for any survey or recovery.
No, what I'm saying is that even it is detected a system. Suppose you're due to pay on that date, there's a red flag comes out. So institution is not paid, when this date. You should, if we all becoming, everything digitized, all records, everything, Aadhaar card is the key to everything. Anyway.
Lordship, here in this case is Lordship, they have deducted they from their side only. They have paid the EPF dues, but it is delayed. So that is why they themselves has paid the delay.
Detection takes so long. If you satisfied that, Anyway, yes, next date.
Lordship, these challans also, if I may, they show that we paid these amounts sometime in the year 2003.
Yes.
2003, Lordship. Now,
yes, we understand.
What I fail to understand, Lordship, is that if I have paid this money in 2003, why are they assessing me till 2006?
No, we understand, yes.
And then why from 2003 they serve me a notice after 19 years?
You take, otherwise it needs a judgment. Anyway, yes, Mr. Sangma.
Obliged.
Obliged, Lordship.
Yeah. Alun.
This is regarding that service where my joining date after my promotion was not counted by the state respondent. That I have joined in as a LDA, and that date was not counted from the date of joining was not counted, and then I was not, due to which I was not given the promotion. Earlier occasion, I have, I think Lordship have heard, we have heard at length, but due to absence of the government advocate, matter could not be complete the hearing. But this is the case where Lordship, hearing he was regularized twice.
He's still working now?
He's still working as an LDA. Only grievance is, the rule also is very clear, Lordship, that the annexer, in my rejoinder I have annexed that rule.
My God, how many affidavits are here? 6, 7, 9, 10.
This is the private respondent's affidavit, but they are only, the statements are same. But the statements.
Where's the affidavit state?
Actually, I filed on the.
When?
Also on the 12th of September.
Number 4.
Watch it.
So you didn't run, you haven't rendered 3 years what boy?
Lordship.
No.
Not around 7 years.
As what boy?
As a ward boy. Then after 7 years, they have regularized my service as a ward boy. First, initially, the annexure one. Initially, I was appointed as a ward boy on 27/6/2002. Annexure 1, Lordship. Annexure 1. Annexure 1. Then on 27, was appointed on 27/06/2021. Then Lordship, after that, yes, 3 years, Lordship, not 7 years. So sorry. After that, that
temporary
was
appointment.
Regularized,
Okay.
yes. The annexure 2, there my name is the last, the annexure 2 type copy.
Annexure 2?
Yes, annexure 2. There I was regularized as a ward boy. As a ward boy.
That is on 2007.
Yes, 2007. Yes, on 30.
Then you have no claim for LDA.
Thereafter, Lordship. Thereafter, annexure
Yes.
3, Lordship.
Yes.
Then on the recommendation of departmental promotion, dear Lordship, that's annexure 3. Annexure 3. They have the department, the DPC, that they have promoted me to the post of LDA. Promoted me here. May I just read it? On the recommendation of departmental promotion, Family Welfare-based Departments, Archival Data, Meghalaya, in white letter dated so-and-so, dated Bakmara, on 15, so-and-so, the C. Buddha Sangma, grade number 4, attached to support PhD, hereby promoted to LDA. LDA. That is, it happened on 19 November 2007. Then, subsequently, I joined on 20.
Lordship, this next is 3, Lordship, but this was promotion temporary
Lordship,
basis,
let me just complete, Lordship, whatever my case is, whether irrespective of whether it's a promotion was a temporary or not temporary. I only want that same procedure has want the government to follow the same procedure. Well, the private respondent others, they happen initially, they also happen temporarily, they were appointed. They were not even regularized also. But then their service was counted from the date when they have joined as LDA as a
Your case is a very strange case because this is you were a ward boy from 2007, correct?
Lordship.
Now 7 as ward boy. Now how can you promote it promoted in 7 itself to LDA?
That is the promotion is done by the department.
That is against the rules.
Department.
Lordship, exact.
And Lordship.
1 second.
Sorry.
First appointment was on, temporary appointment was on 2001.
Yes.
Okay.
2001. Then regularized
with effect from 2007.
Lordship.
And promotion was prior to the regularization, Lordship.
And promotion was done on 19/11/2007.
Promotion was done on the 11/2000.
And regularized in the post of ward boy on 30/11/2007.
Lordship. 38.
So you'd be happy with 2007. Forget 2009. Forget 2007. You're regularized with effect from 2009 now, no? Right now, your service counted 2009, correct?
Yes, yes.
Then be happy with 2009.
No, see, what happened that the rule is very clear.
No, the rule is not very clear, but your track record is not very clear. That's why. How could you be promoted before you regularize in the post ward boy? It's against the rules. You can't explain this. That's the only thing, Mr. Salman. You don't have a qualifying service period. You not regularize. See, how do you explain that? And then you see the other order. Where's that? Next year 5.
24, Lordship.
Huh?
Next year 5.
Yes, as per recommendation section committee. So,
this is the district selection committee.
Yes, you're temporarily promoted, so they reverted that, they corrected it. So now your service will count in 2009.
I'm counting from from 2007, from the date when I was joined as
service now is being counted in 2009.
Yes, the government is counting the date from the from 2009, from the day when.
Is he a lawyer, that boy? Are you a lawyer?
Yes, sir, I'm under confidential.
Okay. Yes, you wear a tie, you confidential. You come to a court, it's a court is a term of justice, you have to come properly attired, yes. Yes.
The government is counting my date of service from the date when the DAC have regularized. I mean, from the recommendation.
This page 25 will be.
Lordship, may I clarify?
Yes.
Lordship, when there was a vacancy with regards to the post of LDA, the petitioner had sat for the exams and he cleared the exams, and hence he was given the regularized post of LDA, Lordship. Not as
2007, 2009.
2009, Lordship. Hence he was regularized in 2009 after giving the examinations and where he had cleared the examinations and the interview, Lordship.
No, what about 2007?
2007, Lordship, that was a temporary.
You accepted, Mr.
Temporary promotion
Salman.
because there was no.
Just see your prayer.
Lordship, page 30, Lordship.
That's the only thing. That's the only thing that struck the court, that you hadn't have the qualifying service for regular promotion. That's the only thing.
Yes, Lordship, but it is.
Yes, correct. I mean, I understand your case. You should be given from 2007, according to you, but the laws don't allow that.
But it is a department, Lordship. But in other, in the other private respondent, they have.
Well, ministerial service rules.
Lordship, I brought one notification, Lordship, dated. I couldn't annex it in my affidavit in the earlier occasion, Lordship, since I didn't have it with me. Lordship, can I produce it?
Let's see.
This is regards to promotion, Lordship. May I read, Lordship? Even so, Lordship, as per the notification, Lordship, the
Yes.
the joining of the petitioner cannot be, I said, for
We are
purposes
not
of
claiming
promotion.
for retrospective effect, because we are claiming only from the date when the departmental DPC, Departmental Promotion Committee, have promoted me. Only that is. Here it speaks about retrospective. I never claim for the retrospective. I will just saying only that service should be counted from the date of when the departmental promotion, the committee have promoted me to the LDA. And from the date of joining, that was on 20 November 2007. Otherwise, in the DSC, that rule also is there, where I have annexer also, that it's also is very clear, Lordship, where it says irrespective of this one, Lordship. I have annexed it. This one is annexure.
Why do you accept this? Why do you accept this? This regulation with effect from 27/8/2007?
27/8/2000.
It's all right. Orders issued 30/11, but given from 27/8/2007, you've given as ward boy, correct?
Yes.
Ward boys.
Yes, that I agree. That from 2020, November 2007.
You accepted your
2007.
your organization as ward boy from 27/8/2007. Okay, you don't have 3 years qualifying service, correct? To go to next high promotional post, which was given 19/11/2007. So this can only be treated as a temporary, what do you call it? A promotion against officiating vacancy. So then.
But if I'm considering the on the DSC.
You can't consider, yes.
No, the DSC rule might say, Lordship. DSC rule says, Lordship, in my rejoinder, I just want to read it, Lordship. My rejoinder, Lordship, it's page 16, Lordship. 16, because the DSC, I have cleared the DSC. I will regularize that also has to get into consideration, because other
Where's the rule, Mr. Karwala? Have you brought it?
No, Lordship. Also,
Where's the rejoinder?
There's a page 16, my lord. I just wanted to point out page 16 that the rule says where that even I have enclosed even the district selection committee also have recommended this rule, your lordship. Just what 2.91 and 2.92. Just wanted to read, your lordship. Only these two.
Where in your rejoinder?
Yes, lordship, in my rejoinder. In my rejoinder, rejoinder affidavit. Page 16. Page 16. Just will read only these 2 points which I am trying to want to.
Which one?
2.91 and 2.92. There only. It says that seniority of the person appointed through or after the recommendation of the district selection committee shall prevail over any other person appointed without the recommendation of district selection committee. Second, 2.92.
What are you trying to say by placing these two sections?
This, I'm saying that because the private respondent, none of them, only 2%. There are many private respondents. Most of them they don't have this. They were not recommended by the district selection committee, but their service were counted from the date when temporarily they are temporarily appointed, and their service was counted from the day when they were joined as a LDA. Then they were given promotion to the UDA.
They all been given promotion to UDA?
No, Lordship.
They've been given promotion to UDA, these people?
No,
They've been given?
They were given.
Where you made a statement?
Lordship, in my petition I have I have stated to Lordship. Yes, in para page 8 of my petition. Page 8, last para, where it is started from, it is submitted from there.
Yes.
It is submitted that the above mentioned private respondents were not recommended by the district selection committee for the post of LDA. However, they were promoted to the post of UDA under divisional assistant, upper divisional assistant. It is stated that the above mentioned private respondents have not been obtained the recommendation from the respective district selection committee, and they have joined as LDA only on temporary basis, and their service were counted from the date of joining as LDA, and accordingly they were promoted to the UDA considering their past length of service. But surprisingly, the state respondent have not considered the initial joining of the petitioner as LDA. That is, the petitioner have joined the initially LDA as on.
Where the duration list?
Lordship.
See, now this one upon 1001 without recommendation.
May I please, Lordship?
Yes.
Lordship, can
There's
I,
no
Lordship, the first next year with regards to the respondent number 6, Lordship, is that page number 31, Lordship.
Or repetition.
Of the repetition, Lordship. Whereby it is stated that respondent number 6, Lordship, Smriti Fenilia A. Sangma, daughter of so-and-so village so-and-so, is appointed as to officiate as storekeeper on ad hoc basis for 2 months with a break of 7 days in scale of so-and-so plus other allowances and so-and-so. And this was, her day of joining was 11 April 2001, Lordship. Please note.
Officiating?
Yes, Lordship.
Then?
Now, Lordship, if I can take your Lordship to page number 20, whereby the respondents, along with the petitioner,
this person was
regularized, Lordship. Lordship, the respondent number 6 and 7 and 8, Lordship, were regularized as LDAs, Lordship, in the year 2007. Whereas they have been working on officiating basis for a couple of years since 2001 or so, Lordship. And in the same notification where the respondents number 6, 7, and 8 were regularized as LDAs, Lordship, the petitioner was regularized as ward boy.
Okay.
Hence, the petitioner has no case.
Otherwise, my lord, there are two things. Another is DSA recommendation. Another is without DSA. Even if I'm taking from the DSA, also I'm.
What's the recognized in service? That is the thing. So you're talking about counting of seniority should be the person who entered first, who's kind of DSC should be counted senior to people who are serving temporarily. Correct.
My money only thing.
You also entered service without any selection.
I'm not insisting.
You entered service ward boy only without any selection. Correct.
Even same
you
thing.
Entered, same thing with them also.
Same
so
thing.
they entered as LDAs temporarily also. You entered as ward boy. Then you given regularization with effect on 25/8/2007. Then you by stroke of luck you went to in November you given LDA.
Yes, Lordship, but yes, even if I've
But
taken
then at that
from
point of time,
2009 also, Lordship.
you accepted the 2007. If you had not accepted it and said, "No, my date realization should be with effect from," as ward boy is when the first appointment.
2007.
No, as ward boy you started service when?
From 2007.
Ward boy 2007 was he started. First appointment.
From what boy? From what boy?
What boy started on?
From 27/8/2007, Lordship.
2000.
As what boy started service?
He started as 27/6/2001.
No, as officiating.
Officiating.
See, there's your mistake. If that time when the regulator said no, I should be given 1001, then fine. You have served 6 years as ward boy, then you'll be eligible for promotion as per qualifying service, you'll have 3 years.
No.
You'll be senior to them also.
Now one thing is now I'm LDA.
Now one thing you can't do anything.
No, Lordship, now I'm working LDA. That they can, what is the problem with the government to promote me to the UDA?
No, now they'll consider your promotion to UDA.
Yes, let them at least, yes.
Because you see what happened, Mr. You understand? Suppose Mr. P.T. Sangma was a lawyer. When did you start a practice?
2011.
See, suppose the lawyer 2007 that time, when this Buddha Sangma came with this order 30/11/2007, you would have challenged it. You would have said, why are they giving you from 27/8/2007? Correct? You have to ask from 2001 when you first, appointed ad hoc. Then you would have got a prayer that time. Then your order for regularization will be with effect from 2001. Then by the time this order came in 19 and 2007, you are eligible for promotion to LDA. You would have jumped over all of them. Then 2007 you've been LDA in 2007.
Lordship, only.
But now what has happened is that because from the root, that mistake he didn't claim for his regularization from 2001. So he accepted the 27/8/2007.
Only Lordship, my only prayer is that I will not correct with this one, but only that since now I'm a LDA, because if there is a vacancy, the government should that observation may be made. Only that if there is a vacancy, I should be promoted to the UDA.
Can we make that caveat that?
Because giving a promotion to the petitioner is not going to affect anybody, none of the private respondent, because they cannot say also, because it is only say if when the vacancy arises, I should be given a promotion. Only that much.
We'll make the order very short. Or you take down, we are only 130. The petitioner was initially appointed as a ward boy on 27/6/2001. But and was regularized in service by order dated
30.
With the order, that regularization, the first regularization.
What's about page number 19?
Page number 19.
By order dated
30th November 2007.
30/11/2007, with effect from 27/8/2007. Stop. It appears that on recommendation of a departmental promotion committee, on committee, the writ petitioner by order dated 19/11/2007 was allowed to be promoted against the existing vacant posts of LDA. Stop. His services in the post of LDA, then by order dated 2/6/2009, were regularized with effect from 3/6/2009, and it was recorded therein that the earlier promotion was temporary. Yes. Stop. So you agree with this order, correct? Yes.
No, Chief.
Yes.
Yes, I agree with this. Yes, Lordship.
Yes. Thomas, last line.
Services in the course of LDU, then by order dated 2/6/2008, were regularized with effect from 3/6/2008, and it is recorded therein that the order of promotion is temporary.
Was temporary. Next, the petitioner on not being granted promotion to the post of UDA is therefore before this court for directions that he be considered, that his services as LDA be regularized from 2011
Yes.
2007,
Lordship.
the date on which he was allowed. Whether order? Whether
Lordship, page 21, Lordship.
the first one? Yes.
21.
He was
Page
allowed.
21.
Lordship, petitioner made some.
Where he was initially promoted to LDA. Stop. Next paragraph. Mr. P.T. Sangma, the counsel petitioner, has strongly argued that the petitioner, having been promoted, by the order dated 19/11/2007, for all practical purposes, his services to the post of LDA should be counted from this date. He has further submitted that in view of his regularization being counted from 3/6/2009, the writ petitioner has been deprived of promotion to the post of UDA, whereas the private respondents have been given this benefit. He therefore prays that as the initial promotion order be considered for granting his prayer for regularization in the post of LDA. Stop. Next paragraph. Mr. H. Karanlang, in reply to submissions of, Mr. H. Karanlang in reply has submitted that by order dated 30/11/2007, the writ petitioner was regularized in the post of ward boy with effect from 27/8/2007. And as such, for counting of a service towards promotion to the next grade. No problem? Sorry.
In reply, as submitted by order dated 30/11/2007, the petitioner was regularized in the place of work boy with effect from 27/8/2007, and as such for counting of the service towards promotion to the next grade.
To next grade was not eligible to have been considered for promotion as shown in the order dated 19/11/2007. Stop. He further submits that the promotion of the writ petitioner to the post of LDA was at the most a temporary arrangement in view of the vacancy in the said post. As the writ petitioner I'm sorry, Thamna.
He further submits that the promotion of the petitioner to the post of LDA was at the most a temporary arrangement in view of the vacancy in the said post as per petitioner.
Was at the most Thamna?
He further submits that the promotion of the petitioner to the post of LDA was at the most a temporary arrangement.
Yes, temporary arrangement.
Of the vacancy in the said post as per petitioner.
The word is post stop. He further submits that unless a member of the service has completed 3 years of service in the lower post, he shall not be eligible for promotion. Stop. He therefore submits that the writ petitioner, having been regularized in the post of ward boy on 27/8/2007, there was no possibility of his being allowed to be promoted on a permanent basis from 19/11/2007. Even then, from this one also still, it has not completed also 3 years from 27/8/2007.
Lordship. Also, hence, in 2009, he had paid for for examinations, Lordship, to get the...
He also submits that as the writ petitioner had appeared before the district or before the Department Prosecution Committee and sat for the exams in 2009, he was accordingly granted promotion to the post of LDA. Stop. With regard to the other aspect of the case, that is the alleged supersession of the writ petitioner by the private respondents, the learned GA has again referred
Assistant Senior Lordship.
The learned senior government advocate has again referred to the order dated 30/11/2007 to show that the private respondents number They were all given as 6 and 7. That's Biki Marak and Tira Marak.
6, 7, 8, Lordship.
3 and 4. Marak and Kirindira, Tetilia, Isama.
6, 7.
They appear when in the list?
Serial number 3 and 4, page number 20.
No, where they appear?
Serial number.
Serial number 3 and 4.
Lordship 2, 3 and 4, Lordship. Respondent number 8 finds himself at serial number 2 of the notification, Lordship.
Number 8?
Lordship. He has expired, Lordship.
Then?
Number 7 appears at serial number 3, Lordship.
Number 4, no. Serial number 4 is the respondent number 7.
No,
and serial number
7 is 3. And 6 is 4.
Serial number, serial number 3 in Marak is a respondent number 7. And Srimati Inelia A. Salma is the respondent number 6.
Appears at serial number 4.
Yes.
Now storekeeper is above what boy?
Lordship is in the same grade as LDA.
No, the grade of PSC is the same because of scale of PSC. So these are the only 2 responses remaining.
And 3 remaining respondent 9 and 10. They are junior to Mr. Sangma.
So he has no grievance against them.
They therefore unnecessarily implemented the respondent 9 and 10.
With regard to the other aspect of the case, that is the alleged first session of the petitioner by the private respondent, the learned additional CJ again referred to the order dated 11/2007 issued by the private respondent.
And to submit that the concerned respondents, that is respondent 6 and 7,
yes,
had been regularized on 27/8/2007 to the post of LDA and equivalent. And as such, there is no question of the writ petitioner being superseded in any manner. Stop. With regard to other party respondents, he submits that they have been unnecessarily dragged in as respondents in view of the fact that admittedly the writ petitioner is senior to them. So we therefore submits that no interference is called for and the writ petition will be dismissed. Next, Mr. H.S. Sangreso, the counsel appearing for the party respondents, has also supported the submissions of the additional, sorry, too fast, nahi? Mr. Sangreso, learned senior counsel with, who's there with you? Yes, P. Viskarma, for the party respondents have supported the submissions of the learned additional senior advocate. Any further submissions to make? And submits that the writ petitioner has not been discriminated against in any manner. Stop. Next paragraph. Having heard and consulted the parties, and having examined the materials on record, it is seen that the writ petitioner is taking his claim to the post of LDA to be counted from 19/11/2007 on the basis of the order of the same date. Stop. It is, however, pertinent to note that after this order dated 19/11/2007 had been issued, whereby the writ petitioner was promoted to LDA, comma, the order of regularization of his services as ward boy with effect from 27/8/2007 was issued on 30th 11/2007. That is after the order of promotion. Stop. This in itself has presented a contradiction of sorts, inasmuch as there could not have been any exercise of promotion. As a petitioner was yet to be regularized in the lower post of ward boy. Stop. Of ward boy. Stop. However, by the order dated 2/6/2009, the petitioner was then regularized in the post of LDA, and the period for which he stood promoted earlier was taken to be promotion on a temporary basis. Stop. For the sake of convenience, the order dated 2/6/2009 is reproduced here and below, page 25. Huh? So. In the backdrop of these facts, and in view of prevailing law, which makes prevailing law with regard to years of qualifying service for being considered to the next post, the case of the petitioner, the claim of petitioner to be for regularization from 2007, from which date?
From 2007.
From 19/11/2007.
Yes.
Therefore, can it be sustained? Can it be sustained? And as such, though the order dated 19/11/2007 has to be read down. So as such, that portion of the order dated 19/11/2007 has to be read down to mean only a temporary arrangement allowing the petitioner to occupy the existing vacant posts. Stop. Next paragraph. In view of these circumstances, therefore, the prayer of the petitioner cannot be granted by this court, and at the most, the respondents are to give due consideration. You complete how many years now for promotion of the petitioner, subject to valid vacancy and track record to the next higher post of UDA, has been accorded to the other part of respondents. With the above, yes.
Lordship, since there are other three private parties, Lordship, according to gradation list, who are above the petitioner, Lordship, maybe they may be affected by thing, Lordship. If he goes,
why should he go?
If he gets promoted before them.
Why you get promoted? They on UDA, he's still LDA.
Yes, they are already UDA.
Lordship, if I can take your Lordship's page number 46, Lordship, whereby there are some persons.
No, subject to availability of vacant posts. What do you mean?
Yes.
Yes. So vacant posts, yes. And as per regulation list as being maintained. With the above directions, with the above observations, the representation stands disposed of, yes. Yes.
Much press, Lordship.